just quickly want to hand out a remarked assignment so that when you start talking about the assignment, we will have it so you can see. So just when you're just going to pull out the names, and then you must just put up the hands so you can
Okay, I'm going to pull up the Sylvester, you're well. Warren Charlton. What's up going on with this?
We can't hear the patient. It's
Can you hear me? Okay. Maxwell Tiangwa. Peter Jordan.
Yeah.
Daphne Debese. Ramano Hasipia. Tanya Stanley. And this one doesn't have a name, but it has a student number. So if you can identify your student number, please let me know. It's student number 745127. And same with this one. Student number 77408497. Amanda Marie. Benashan. This one doesn't have a name. 744885554. Petras Van Veek. This one doesn't have a name also. 74503073. Tetias Keith. Student number 74216570. Zina Erasmus. Student number 74502956. Doesn't have a name. Another one that doesn't have a name, student number 74504177. Student number 74510184. Student number 74510150. Student number 77982185. Student number 74504344.
Okay.
And Sipokazi Toto. Student number 744892991. Charles Peary. Mereda Rita van
Thank
Boyen.
you. Sorry.
Student number 7448986. Manda Stanley Mkwena. Student number 74206265. Azwi Feleni Zambepa. Mojibi Ismail. Lee Loren Sensi.
Yeah.
I'm sorry about that.
No, it's fine. Thank you.
Student number 74487-094. Student number 77408-497. Student number 744885554. I think we have covered everyone. If anyone doesn't, how do I do it?
Haven't you got yours?
What is the number?
What's your name on the? Okay,
What's
it
the
could be, wait until tea time, and then you
Yeah.
can go through the ones
Can we,
you've got,
can we do it?
and then if you haven't got yours, yes, we
I think there's quite a number of us probably.
Really? Okay, well then it could be in the other heap that we thought were the ones who weren't here. Just come to the front at tea time, and then Professor Quetnell will find it. Okay, because they have all been marked. You should have your marks uploaded on my Excel already. It's just that the mark to sign that is there. The ones I marked, I did electronically, so the marks will be on my Lisa, and you go to your assignment and you click on view, you will see the marked assignment. Okay, right. So starting off, just a few general remarks about the assignment, which really apply to the exam as well. Nothing new here, it's in your tutorial letter 101. Some of it I repeated in tutorial letter 103, but some of you either don't read the tutorial letters or you read it and decide to tutorial. First of all, as you see now, please put your name and student number on your answer. Sometimes they get separated from each other and then we have to identify it, and we want to double check that we're giving the right marks to the right person. So always put your name and your student number on the very first page so that we can identify it. That's quite important. Those of you, not many, I think only 2 or 3, who may still have problems with my Unisa, you will see in tutorial letter 101, there are 2 email addresses of people who can help you sort out your problems with my Unisa. It's really important that you do that before exams because you have to download your exam paper or questions from my Unisa and you have to submit the answers on my Unisa. And it's not a good time to find out that there's a problem with your my Unisa access on the day of the exam. So sort that out before the time, make sure you have access. Also, don't wait until 30 seconds before 4 o'clock on the day that you have to submit the exam, because then my Unisa tends to become clogged and you may have problems in getting your exam answers submitted. So make sure that you've got all that. Also, now, when we get to your answers, remember that the length of your answers are restricted. And if we restrict your answer to 5 pages, we'll mark the first 5.5 pages. And when we get to that point, we stop marking. So do not waste your space. Stick to the question. If we ask you about the notification to affected persons once a board has filed a business rescue resolution, we don't want you to tell us about the history of business rescue. We don't need you to tell us what the requirements are for commencement. We don't need you us about all the results or consequences. We want you to stick to what must you do, why must you do it, where is it prescribed, what are the results if you don't do it. So stick to the question, don't waste your space or the word count, but I think we'll limit it to page numbers so that you can actually stick to and get the information that will earn you marks in that space. Also, if we have to wade through pages and pages of irrelevant information, we may actually miss the parts that would have earned you marks because we've got a lot of things to mark, so we tend to speed up when we see it's not really relevant. So please stick to the relevant parts of the work. You don't need to repeat the question before you answer it. We actually have copies of the answer. Your question, we do remember what we asked. So you don't have to tell us.
In fact, if I may add to that, some of the people who didn't get good marks, sometimes people will just tell you everything they know about businesses, and you find that in the answer there is the correct material, but then it doesn't show that the person understands because they are not connecting the question and the information that they have, so it doesn't show that they really want.
Yeah, we call that the shotgun method, and we know it. We deal with it all the time, where people who don't actually know the answer just give us everything they can think of, everything they know, and then leave it to us to pick out the bits that would earn them marks. You don't get very good marks for that sort of answer. We want you to be able to identify the specific problem or issue addressed in this question. That's the first step. You must be able to see, okay, here's the problem. I know this problem. And for that, you actually have to prepare properly for the exam. Don't fool yourself by thinking, oh, this is easy. I've got all my material with me. I've got 4 days to write this exam. I don't have to prepare. I'll just look up the answer. You won't be able to do that because you'll either run out of time or you will not recognize the issue or the problem that is raised in this question. If you don't know the work well enough, you won't be able to see what it's all about, and you will address and answer something completely different, which is not relevant and not what we want. So please make sure that you do proper preparation. Also, everything you need to know for the exam is in your prescribed textbook, or at least in the prescribed parts of the textbook, but make sure it's the 4th edition. The 3rd edition dates from now 2013. I can assure you a lot has happened since 2013. So it's in your textbook, it's in the Act, in the Companies Act, and in your tutorial aids. That's all you need to know. So please, when you answer your exam, don't go crawling onto the internet for all sorts of weird and wonderful websites that could perhaps give you an answer. Firstly, they're very often wrong. Secondly, even websites of law firms are often wrong because it's the opinion of 1 or 2 people, very often a candidate attorney and his principal who didn't actually check very well. So it's not necessarily right. And you don't need to, you're not going to get any marks for that. We're not going to be impressed by the wide search you did. You must stick to the prescribed study material. That's where the stuff is that we want. If you use that, that's when you will be able to answer the questions. You don't need anything else. Once you're out there in the real world, if you really want to consult other sources, you have 2 possibilities. The one is the textbook by Enochsburg on the Companies Act 71 of 2008. It's a loose leaf publication. It gets updated twice a year, and it's well written. It's correct, it's well written, it's substantiated, and it's updated. But it's a very expensive book, so you don't buy this book if you don't actually need to know all that detail because it's very detailed. And the other source, which is also a secondary source, would be articles published in accredited journals. These would be law journals published by the various law faculties, colleges of law in South Africa, because these are peer-reviewed. In other words, when somebody submits an article for publication, 2 other experts get this article, it's a blind review, they don't know who wrote it, and they must agree that this makes sense and it's correct. That's the only other sources you can trust, but we won't expect you to use them for purposes of the exam. It's really only once you get into practice and you really need information. You'll see Professor Lefenia has got the book Contemporary Company Law here. I would not advise you to use it because this, although it's the second edition, it also dates from 2013. And a lot has happened. We've had cases that are becoming thick and fast, and each one makes a difference. This book is now in its 4th edition. We published the first one in 2011, then we published a second one in 2012, then we published the third one in 2013, and we're now on our 4th one because things change so quickly. If there is anything, if anything really dramatic happens between now and the exam that I feel you ought to know, I'll put it on my Unisa under announcements, but it's unlikely. I think what you've got enough already with your textbook, the Act, and the tutorial letters. So just make sure you read those tutorial letters from beginning to end. Also, please read the instructions at the top of the exam paper. They are also important. To a large extent, they repeat what we've already told you, but just repeat that again. Okay. The other thing is, and I think many of you have now found that to your cost, which was also very clearly stated, I think in bold letters in tutorial letter 101, do not quote directly from the Act, from a judgment, from the study guide, from anything. We want you to use your own words because that's the only way you can convince us that you actually understand what the Act or the judgment says. Also, the textbook is not really authority for the law. The authority for the law, for legal principles, you find in statutes, in other words, in this case, the Companies Act, some maybe a little bit in the Labour Relations, but not much, mostly Companies Act, and in judgments of the courts and common law principles. Common law principles nowadays you also basically find in the judgments because the courts will say this is what the common law states and this is how it's been amended, or we still apply that. Those are the only sources. The textbook, in other words, is not a source of law. It explains the law to you. It tells you what the law says. But if you tell us, let's say, for instance, as in the assignment, that a person can make a binding offer to purchase another affected person's interest, the authority for that is not the textbook. The authority for that is Section 153 of the Act. Yeah, it's 153. Okay, so you only basically have those three sources, which you must always mention. You can't just say an affected person can make an offer to buy another affected person's interest. Because first of all, it's not just an offer, it's a binding offer. That's where the whole problem started, so it's important that you must be exact. And secondly, you must refer to the source, in this case, the Act. So you must say where that comes from. It's not something you just thought of yourself, it is something that is in the Act. So you must always mention your source, preferably not in a footnote. It makes it very difficult if we have to jump up and down all the time between a footnote and miss important information if you put it in a footnote. So instead of saying you can make a binding offer and then have a footnote referring to Section 153, you write in your text, Section 153 allows an affected person to make a binding offer. That's it. You've got your authority and you've got your principle of law. You don't need to use footnotes. Let me see. Okay, I think that's all I wanted to say. Was there something you wanted to add? Okay, any questions you want to ask about the exam?
Yeah, I just want to point something like you talk about teaching of papers, but sometimes you can find that like for instance in our site we're talking about 4,000 weights. And if there was something you find that we are not yet, but it teaches maybe if which was approximately 7 things. So I look to see what maybe I can provide because I'm not yet to 400,000.
Okay, it's really an estimate, but we usually give you more than you need. A 10-mark question should not really take up more than 5 type pages. I think about 5, and then we give you 7, which means if you have 7, 8, 9, 10 pages, you're writing too much. writing stuff that's irrelevant, and that's not going to earn you marks. So it also gives you an indication. The marks will give you an indication of how much information we need, and then also how long it should be.
Prof, got to spacing. What spacing do you specifically want? You know,
I
I was
think-
using about 2.
Yeah, I think 1.5 would be enough. Because we don't, in the olden days, when we mark by hand, we needed space to write comments, but now that we do it electronically, we don't need that space. So it's just, a single spacing is not enough, because then it's too, sort of, you mark late at night, it becomes a little bit blurred. But I think 1.5 spacing should be fine. But make it Arial 12, so don't make it too small.
I mean, I was using error of 12, but then the spacing was 2.
Yeah, 2 is a little bit too much. You can see the spaces are quite big. So rather use 1.5 and maybe just a space between the paragraphs so that you can see this any thought that's coming up. Okay, but we're not too technical about that.
And going back to the question, one of the things that when you mentioned that sometimes people, when they are referring to cases, they will also better give you everything, give you the facts, the background, and I think it helps you to just go through the relevant things. That's something she considers the idea of the presentation. Because otherwise, rules and other things that are not relevant.
Yeah, the facts of the cases are usually not that important, except for the specific facts which have a bearing on the question that we ask. Where and why the court had established that principle in the case, why the court gave an order and the way it did, or the judgment. So just stick to the relevant facts. You don't have to tell us everything about it.
Sorry, regarding your cases, you want full cases in whatever, or
No,
how do you
just
want?
enough to, so you say DH Brothers versus Griplets, the first time you refer to it. After that, DH Brothers case. So the first time helps because then we know exactly, except when you've got a case like the Kariba case where there's a High Court and a Supreme Court of Appeal judgment. There you need to make the decision, but you don't have to give the full reference. You can just say Kariba and then in brackets High Court or whatever, or Court of Appeal, whatever you want to refer to, just to make that distinction. But if there's only one case with that name, you just give us enough so that we can identify the case that you're doing. Any other questions? Yes.
Sorry, will past papers be made available to us?
No, because it is a non-venue based exam that you have access to the internet. It's only if we start making papers available, it's only a matter of time before somebody sells them on the internet. We've had that experience. So we don't do that. We do give papers where it's a venue-based exam where people can't get onto the internet or whatever. But for these, no, because then you will find it on the internet within weeks. I actually found notes that we made available in March this year. It's already available on the internet, and it's also like this case, like this course, where it's only electronic and you have to be a student to have access. So some or other person who is registered for that course sold it or gave it to somebody on the internet. Okay, any other questions? Yes.
How many marks for the exam?
We usually make it 80 because the exam mark counts 80% of your year mark. So the assignment counts 20. So if you make the exam out of 80, then you can just add the two together to see. We don't actually calculate the final marks, it's done electronically. But if you want to check up on them, then it's easy for us to do. So it will be 80. The assignment questions were sort of based on previous exam questions. They were just shortened and slightly simplified questions. But that gives you some sort of an idea of what to expect. Yes,
How many questions would the exam paper have?
I have no idea.
Is it like one?
Sometimes.
2 or 8? like short questions or longer questions?
Well, I'm actually going to change it this year. In previous years, I had one question of 50 marks, where I had a complicated set of facts with all sorts of issues, but I'm getting too old for that now. I can't answer that. So it will probably be like 15 marks, 20 marks, maximum 25 marks. Okay, about 25. But short questions. It's not quite as short and simple as in the assignment, but slightly. Right, so you're all happy and ready for the exam and confident that you're going to do well. You didn't do too badly in general in your assignments. A few glitches, but I think in general you did fairly well. So at least you got an acceptable score, so that's fine. Okay. Anything you wanted to add before we? Okay. Now, what I'm going to do today, I'm not going to use PowerPoints because the fact that the textbook is new means that all the information is updated. So everything is there, and the little bit that was missing is what you will find in your tutorial letters, particularly tutorial letter 1 and 2, which is sort of a study guide. So you don't need detailed information. What I did find, however, was when I marked the assignments is that some of you, you can't see the wood for the trees. So you have the detail, but you don't see how the whole thing fits together. So you put things together that don't actually belong together, or you confuse different procedures with each other. So what I'm going to do is, first of all, just go through the structure, sort of an organogram of the whole process, so that you can see the whole thing, how it's supposed to go from beginning to end. And then after that, I'll go back to some of the details, just some of the problems. They are, as I said, discussed in your textbook and in your tutorial letter, just to sort of show you what the problems are. Okay, before we get to that, a little bit of history. Context is everything, as I said. South Africa was one of the first countries in the world actually to have a corporate rescue procedure in the form of judicial management. In 1926, when almost nobody else had it, in our Companies Act of 1926, that was the first Companies Act that applied to the whole of South Africa, the Union of South Africa as it was then, as a British colony. So, understandably, the 1926 Act relied quite heavily on English law. And you still find remnants of English law in our common law. You still find certain principles, third-point rule, and stuff like that, which we inherited or took over from English law. However, judicial management, the corporate rescue procedure, was not in English law. We're not quite sure where they got this inspired idea from, but anyway, so we had judicial management in our 1926 Companies Act. And it was a pure corporate rescue procedure. In other words, the only acceptable outcome was that the whole company had to be rescued. So you had to, firstly, you had to go to court, get a court order to commence judicial management. The court appointed the judicial manager, and you had to prove, on the one hand, that the company could not pay its debts, it was unable to pay its debts for you, but you also had to show that it was highly likely that the company would emerge from judicial management as a solvent, profitable, successful company again. That was the only acceptable outcome. You had to rescue the whole company with shareholders, creditors, the whole lot intact. Didn't work very well, but not too badly. Those of you who use herbal medicines will perhaps know Dr. Lennon's medicine. That was one of the success stories of judicial management. That company was placed in judicial management, got a very good judicial manager who knew how to run the business, turn it around, and it was rescued. And there were a few other success stories as well. When the 1926 Act was replaced with the 1973 Companies Act, or Second Companies Act, there were quite a few people who said we must just get rid of judicial management. It's not successful and it's not working. But the Van Wyk de Vries Commission, who was the commission that sort of wrote the report and the act, decided to keep it because there were a few important rescues under judicial management, so they felt that it was worthwhile keeping it. The success rate was about 5%, which actually doesn't compare too badly with business rescue, where the success rate is 7%. So 7% of all companies going into business rescue, only 7% of the companies emerge and are still in business 2 years after the termination of business rescue. So it's very much almost the same. Okay, then came the Companies Act of 2008. Now, in contrast to the process that preceded the Companies Act of 1973, where we had a judicial commission, they investigated, they invited people, anybody who wanted to say anything about the new Companies Act would come and say that. The drafting of the 2008 Act was a top secret. It was state security. If anybody, few select people who knew anything about this Act, if they told you anything about it, they had to kill you because you're not supposed to know about this. It was very, very secretive procedure. I don't know why. Also, the drafters were not South African experts. They got in a Canadian who was supposed to be corporate law. He didn't know any South African law, but he was supposed to be an expert in plain legal drafting, so that ordinary people can understand the Act. So if you cannot understand the Act, it's your fault because it was written in drafting by an expert in plain legal drafting. Okay. He was assisted by an American and an Englishman. It sounds like one of those bad jokes that you say American and Canadian Englishman walks into the bar or something, but in this case, they walked into DTI and they drafted out the companies. So the whole thing was very secretive, very confidential. Then they published a bill sometime in 2007. It was a disaster. It was very long. Used terminology that we didn't know, conflicted with our common law. It was just terrible. Okay, so they got lots of comments, and then they drafted a new draft bill, which they published a few days before Christmas in 2007. So nobody was interested in commenting, but a few people did because there were still many, many mistakes. As a result, the Act came into operation on the 1st of May 2011. But it was signed into law in 2008. That's why the number is 2008, although it only came into operation in 2011. 10 days before this Act came into operation, they very hastily published an amendment Act just to fill up the really terrible gaps and correct some of the mistakes. It wasn't enough, but it was at least an improvement. So we have an Amendment Act and a Main Act that came into operation on the same day, which is the 1st of May 2011. Now, you don't need me to tell you that this Chapter 6 in particular was not well drafted. It's not just my opinion. Every second or third judgment of the courts, even the Constitutional Court, referred to the sloppy drafting of Chapter 6. So it is badly drafted. There are conflicting provisions. There are gaps. There's some terminology which we don't know in our law, as a result of which the courts had to start interpreting, and some of them just started rewriting the Act, which they're not supposed to do, but still, because the Act was not enough, and they have certain requirements, compulsory procedures requirements, but there's no sanction or punitive measure if you don't follow that. So people just basically ignore it most of the time. Okay, so that is why we have a lot of problems and a lot of judgments even. The High Court, we had different judgments, conflicting judgments from the various divisions. And then if the case goes to the Supreme Court of Appeal, because of our system of precedence, the lower courts, the high courts are bound. Even if they don't agree with the Supreme Court of Appeal decision, and they sometimes say, I don't agree, but I am bound, I have to follow the Supreme Court of Appeal. Of course, if it's the Constitutional Court, we've only had one Constitutional Court case so far, then nobody has a choice, then you have to rely on that judgment and follow that judgment. Right, so that is why we have a few problems that could have been avoided, but yeah, we're stuck with it. The corporate lawyers are very bad about this. They call this the Corporate Lawyers Unemployment Prevention Act, because they have worked until the next century, more or less, in interpreting this act and trying to argue against certain interpretations and so on. Right, so now, I want to give you just a little bit of an overview, just so that you can see how this thing fits together. Now, first of all, as you know, Chapter 6 applies to companies and close corporations. You probably know that in terms of the 2008 Act, nobody is allowed to register a new close corporation. So the ones, they actually wanted to completely get rid of them, but we have more than 1 million close corporations. So in the end, they decided the ones that are already registered can stay there, and not allowed to register any new close corporations. So what they've started doing is to make more and more provisions of the Companies Act applicable to close corporations, and this is one of them. Okay, now when you look at statistics, you'll see 65% of companies going into business rescue are private companies, 3% are public companies, and what's the rest? 32% are close corporations. Which is interesting because a lot of people have said that this procedure is actually too expensive for small companies, even for small private companies. But of course, there are very big private companies as well. So for them, business rescue is fine, but it is a very expensive procedure. There's no doubt about that. Okay, so now you've got a company and you've got a close corporation. Now, when we get to, and they are treated the same. So you have the commencement here. Let me just get my notes back, especially if I actually have software, so I don't confuse you. The procedure is the same for companies and close corporations, except that when you talk about, when it's a company, it's the board of directors, when it's a close corporation, it's the managing members. Okay, but the procedure, I'm going to stick to companies, but you know that it's the same. Okay, when you talk about commencement, you've got two possibilities. The one is filing of, I call it a board resolution. That would be the case in a company. Okay. The other way to commence is by court order. Now, when you look at statistics again, you will see 90% of all business rescues are commenced by way of the filing of the business rescue resolution, because it's much easier, it's much cheaper, and most importantly, there's really no control over it. Nobody checks whether you actually meet the requirements. So court order would be the other 10%, and these are, in most cases, where the company or close corporation is already in liquidation, because then you're not allowed to file a board resolution anymore. So these are mostly the cases where the company or close corporation is already in liquidation, or where the management doesn't want to commence business rescue, and so a creditor or a shareholder decides that this is what they should do. Okay, now when you get to the requirements, again, they are the same. So, you have, let's see how I can put this so that you don't get trouble. Let's see, it's financial distress. We'll get back to all these in detail later on. Financial distress plus a prospect. Prospect of rescue. However, you will see that when you're dealing with a court order, you have two alternatives for financial distress. The one is if the company has not paid any employment-related payments, So it would be salary, contributions to the unemployment insurance fund, contributions to the medical aid, tax payments, PAYE payments, all those things. If a company doesn't pay this, and they only have to skip it once, that would already be regarded as a sign of financial distress. But then, of course, if you go to court on that and it turns out that they're not financially distressed, it's just a bank that made a mistake or something like that, then you won't get your business rescue order, but you can go on that. The reason for that is, in fact, that they have found that many businesses that are in financial or experiencing financial difficulties, they keep it from their employees. So one day the employees turn up for work and they find that their workplace is locked. And there's a sign on the door that says this company is being liquidated or in business risk, well, in liquidation. So employees are not informed in time. That's the problem. And this is supposed to address that problem. The other one is, the other possibility is where it's for financial, if it's just and equitable for financial reasons. Now, we all struggled with this one because surely, if it's for financial reasons, what other reason could there be than financial distress? In other words, the company is unable to pay its debts. You'll see in your textbook there is a reference to a case, Tire Corporation of some sort, where the court said, well, you know what, if I cannot actually get proof of financial distress as defined, but I can see there's a problem. Or rather, no, what he said was, if the company is insolvent, because some people said if a company is already insolvent, it shouldn't be put into business rescue, it should go into liquidation. So the court said, we don't think that's true. They needn't have motivated that because the Supreme Court of Appeal had already said so in the Oakland case, that even if a company is already unable to pay its debts, it can still go into business rescue. But the court said, and just in case I'm wrong, then this would be a case of just and equitable for financial reasons. If I can't bring it home under financial distress, or if the fact that the company is already insolvent means that it cannot go into business rescue, then it can go on this ground. Okay, so you have the two basic requirements, but you have two extra ones for a court. Right. Now, at this point, let's see, we now have, when we get to the procedure, here you say you file, the board has to file the resolution, and it has to be a valid resolution. You'll see that one of the prescribed parts of your textbook refer you to board resolutions, because the Act is very clear about what the requirements are for a valid board resolution. All the directors must be informed about the meeting, there must be a quorum. Every director has one vote unless the rules of the company provide otherwise, and you need a majority decision. You may remember, we may have seen in that DH Brothers versus Gripnitz case, the company had two directors and only one signed the resolution. And then the court said, if you've only got two directors, you need 1.5 for a majority, and 1.5 a director, so then you need both of them. So this was not a valid resolution, and therefore there was no valid business rescue. Okay, so you have to file a valid resolution, and you also appoint your business rescue practitioner. So that's also what the board will do, and you have your notifications, which I'm sure you are all now very familiar with. Okay. Now, somewhere here, before you get to this point, you have the so-called section 129(7). In other words, the board comes to the conclusion this company is financially distressed. But for reasons that they might regard as a good idea, they do not file a business rescue resolution. Then this section says you have to notify all your affected persons of the fact that the company is financially distressed and that you are not going to commence business rescue business rescue proceedings. And you have to tell them what. You have to tell them why the company is in financial distress, what are the circumstances, and then tell them why you're not going to go into business rescue. Now, you can imagine if you're a creditor and you get a notice from the company that owes you money, okay people, we can't pay our debts anymore, but we're not going to do anything about it. What do? You rush off and you sue them and you try to get payment before things go completely wrong. For that reason, nobody sends out such a notice. So they just ignore it. It is actually a contravention of the Act, but Section 129, and specifically subsection 7, doesn't say what happens if you don't do it. It is probably a breach of your fiduciary duties or your duty of care and skill towards the company, but then it's only the company that can claim damages from you. And if the company has gone into liquidation, that's it. The company no longer exists. There is the section 218(2), which states that any contravention of this act by any person, as a result of which any other person suffers damages, will make the person who contravened the act liable. Now, the idea was that maybe this should cover this type of thing as well. The courts are not very happy about the section 218. They don't like the idea of that any person can be held liable for any contravention of the act, for any damages suffered. So they either say, well, this is not strictly speaking a contravention of the act, or they would say, well, you know what, section 214 contains the criminal acts, and there are very few criminal acts in this new Companies Act. They try to decriminalize it, so there isn't much of that. So the courts will say, you know what, this is not really a contravention of the act, it's just, not following the procedure. They just don't like the idea because it's so wide. On the other hand, I've seen one or two cases where the courts actually did say, you didn't send out that notice, so the creditors kept giving you credit, and now they've suffered damages because you can't pay them, so now the directors carrying on business will be personally liable for it. But not many cases like that. I know of one case where a company did actually send out this notice, but that was intentional. They wanted to go into liquidation, but they didn't have the necessary funds to pay for the liquidation application. So what they did was they sent out this notice, and lo and behold, of course, some other creditor came and applied for liquidation as a company. That's what they wanted, and it didn't cost them a cent. So you can actually lose quite well. And I actually saw the two lawyers on both sides at the same place, and they were both smiling because they knew that. Right. In this case, on this side, you apply to court. Now, in most cases, this application is, of course, opposed by somebody, which means that it takes very long before this application is actually heard by the court, and that's one of our practical difficulties. It can take up to 18 months from the time you file your application with the registrar of the court until the court actually gives you a judgment to say yes or no. But in terms of the act, the business rescue commences when you file that application. So you'll see, we'll get back to that later on. There are all sorts of ways in which the courts have sort of tried to get around this problem to mitigate the results. However, the one result that they couldn't get around was the fact that when you file your application with a court, it suspends your liquidation. Yeah. So, people make this application with no hope in hell to ever have a business rescue order issued, but for the next year or 18 months, the liquidation procedure is suspended, which means they can shred documents, steal the bank account, anything, whatever they want to do. They've got lots of time to do that. So by the time the court hears the case and says, well, this is very obviously not a good case for business rescue, it's all gone. And the interesting thing was, there was a project at the University of Victoria where some business management students did a project where they looked at companies that went into business rescue, mostly by filing of a bond resolution, and then this didn't work out all that well, and then eventually the company was liquidated. And what they found was that the assets listed by the business rescue practitioner, when he had to supply that list, when the company went into liquidation, a lot of those assets were just gone. They were just missing. No trace. Gone. Missing. All. As a result of which, the creditors then eventually get a much lower dividend, if any at all, in the liquidation, because some of the assets have disappeared. Okay. And some of them, of course, have been spent to pay the costs of the business rescue, and some of them just seem to disappear. Okay. The court also here appoints the BRP, that's the business rescue practitioner, but it's only a temporary or interim appointment, because at the first meeting of creditors, the creditors can either ratify this appointment or they can choose somebody else. In most cases they don't, because maybe they don't know anybody else, or they feel, well, he's already done a lot of work, why get somebody else in to start from scratch? So they usually keep the person who is appointed. Okay, so that's your procedure. You have the commencement, the two ways of commencing, the requirements, which are basically the same, except for those two extra ones, and then the procedure, and then this section, which is, I suppose they had good intention. They wanted the directors to act the moment they realize that the company is in financial distress, because it's been proved over and over again that the sooner you start your business rescue or reorganization, the sooner or the better your chances of success are. If you wait until the company is hopelessly insolvent, your chances of doing any rescue of any sort are not all that good. So they wanted basically to force the directors to just put the company into business rescue as soon as they can see the problems coming, but it hasn't actually worked out that way. So this is one of the provisions that everyone just ignores. Yes.
Can I ask, if a company is already in liquidation and somebody comes and says, or applies to the court to go into business rescue, and it takes 18 months, does that liquidation process continue until the court approves the...
No. We'll get back to that when I get to the details, but no, it doesn't. And that was also because the Act doesn't say. Just one of the many things the Act doesn't say. So, okay, well, let me do it now, because then I don't have to talk about it again. This provision specifically in section 131(6), which states that a business rescue application, and the Act is very clear, it's the application that suspends your liquidation proceedings. Now, there were various problems. First of all, what does the Act mean by liquidation proceedings? Does it mean court proceedings? Does it mean the procedure that comes afterwards when the liquidators sell the assets and pay the creditors and submit a liquidation distribution account? What exactly is suspended? And then the other problem was, who's in charge? Because the directors then would say, oh goody, the liquidation is suspended, we're in charge again now until the court hears the application. There was a conflict of opinion, of course, but the most sensible one then was that if you make this, first of all, when do you regard this application for business rescue as being made? Just by filing your application with the registrar of the court? The court said no. You must at least notify all the people that you are supposed to notify in terms of section 131, because the section 131 states that when you apply for business rescue, you have to notify the company, you have to notify the creditors and the shareholders and everybody else. Everybody must know that you made this application. And you must also serve it on the company and on the CIPC, the Companies and Intellectual Property Commission. So the court said you cannot say that this application has been made before you've notified all those people. And if the company is in liquidation, you must notify the liquidators, because they won't know that their liquidation has now been suspended if they are not notified. So they must be formally notified. So that was the first thing. You cannot just file it with the registrar and say, well, now everything has been suspended. It's only after you have filed and served your application. The second question then was, what proceedings are being suspended? Because the Act says liquidation proceedings are suspended. Some courts said, well, it's the application, it's the court proceedings. Others said, no, it's not the court proceedings, it's the procedure that follows afterwards, when the liquidation order has been given and the liquidators start selling off assets and paying creditors. That's what's being suspended. Others said, no, it's the whole thing. Application to court and what follows afterwards. Eventually, the Supreme Court of Appeal, and those cases are in your textbook, the Supreme Court of Appeal said that it's everything. You even have a case which is your application for liquidation, so your application hasn't even been heard. Even your liquidation application is suspended right up to the end, when you get to the point where the liquidation and distribution account has been approved, it's been published, just before the CIPC gets to the point which they have to do after liquidation, where they deregister and dissolve this company. Just before they do that, even that is suspended. So you could get a whole liquidation process that's up to the very, very end. Everybody's been paid, all the assets have been liquidated. They're just like seconds away from dissolving and deregistering the company. And then somebody can stop it right there with a business rescue application. So it's the whole thing that's being stopped. The obvious question then was, okay, now who's in charge? Because the liquidation has been suspended. It could take months before the court decides whether to grant the business rescue or not. Let's start with the correct one. The one that said, and that's in your textbook, where the court said the liquidators are still in charge. Because the moment you put a company into liquidation, the directors are removed. They lose their powers. It's over. They are removed nominally and legally. They have no powers, so they cannot step back and take over the company again. The liquidators are still in charge. They cannot do anything about liquidation. They cannot sell assets. They cannot pay the creditors because the procedure is suspended. But they are still there. They have to be like caretakers of the estate property. Then a judge in the Gauteng North Division came up with a bright idea which has absolutely no basis in the law. He just thought this sounded like a good idea. And what he said was, the liquidators can't be in charge anymore, even as caretakers. So I think, strictly speaking, the directors are in charge again, but of course, we have a small problem there with the law. So what we'll do is I appoint a manager. And this is the person that the company wants to have appointed as business rescue practitioner. And he will manage the company together with the directors until a court hears the business rescue application and then either appoints a business rescue practitioner or decides against it, in which case the liquidators will of course step back into power. Fortunately, and that was a disaster, because you can just think of the abuse that can happen if the directors give the powers back again, and they choose somebody of their liking to be their manager, future business rescue practitioner. Fortunately, this case was taken on appeal to the Supreme Court of Appeal, and the Supreme Court of Appeal said this is absolute nonsense. So I didn't use quite that language, but basically. There is no authority in the Act for the appointment of such a manager, whatever you want to call him. It is, what is suspended is the proceeding, the procedure, but not the liquidation, because if a court refuses, dismisses the application for business rescue, the liquidator automatically revives, and the liquidators automatically get all their powers back and they can carry on with the liquidation. So in other words, it's the liquidation procedure, the liquidation of assets and payment of creditors, etc. That is suspended. But the liquidation order itself is suspended, but it's not cancelled. It's still there. So the liquidators still have their powers to take care, to act as caretakers of the estate of this company, so they are still in charge. The directors are most certainly not in charge, and neither is a manager or anything. So that at least I can see. But there you can see a good example of bad drafting. They say it's suspense, but they say nothing else. So they don't say who's in charge, they don't say what they mean by liquidation proceedings.
Just a question regarding, if the company has not gone into liquidation as yet, then obviously there's no liquidator that's managing it. Who then takes over?
Yeah, that's the other problem, because the Act says the liquidation, the business rescue starts when you make the application. But the business rescue practitioner only gets appointed once the court gives you the business rescue order. So basically the directors remain in charge because there's nobody else. Which is why they can use this opportunity to destroy a little bit of evidence and move around.
Yeah,
Yes.
I just want to say that in a situation whereby I am appointed with a practitioner, with a year, then the board of directors will that the done of my activities. Now maybe they want to add another EC, two companies also to be part of the business practitioner. Now the one that was appointed for the first time doesn't want this to come, they want to bring it to court. How is that? Because now the board of directors said that after this company is under business, who said the board of directors are no longer in charge. I am in charge. So now they come like through the window. They want to impose another business rescue practitioner.
Yes, the Act actually deals with the appointment of a business rescue practitioner when the current one dies or resigns or is removed. And the people who originally appointed the business rescue practitioner, there's a big case about it in the, and the Optimum Minds together, all these Gupta companies. That's one of the problems they have. And there is a recent judgment, but unfortunately it was very confusing because they had business rescue practitioners too. Then the business rescue practitioner appointed somebody else who was a junior practitioner. Then the original ones resigned, so they left this one junior practitioner who was not allowed to be a business rescue practitioner on his own of a big company, Then they had this fight about who is allowed to appoint a new business rescue practitioner. I think in this case, because it was a board resolution and the business rescue practitioner takes over all the authority and powers of the board, they said, well, then he can appoint somebody else. Because he has to appoint somebody else. He's not allowed in terms of the Act to be the sole business rescue practitioner. If you want to read that case, it's Wendy Dawson versus somebody. But it's really, really complicated. Even my eyes just glazed over. I thought, oh, it's time being. And one day when I feel better, it's fine. I'll read it again. But it is a problem. Who has the authority to appoint? It seems like if it was a court appointment, then the creditors get to nominate because they are the people who originally nominated the business rescue practitioner. But if it's a board resolution, then apparently the board doesn't have the authority anymore because the business rescue practitioner has taken over their authority. So the business rescue practitioner. Because in this case, I mean, they were just appointing and resigning and disappearing and then appointing somebody else. It was chaos.
Because we are faced with this situation, that's
Okay, just write me an email and I'll send you the reference of that case and more or less what the court said. But it's not, I don't think they've completely solved the problem, but and it's not a Supreme Court of Appeal case, so the Supreme Court of Appeal would have to opinion. But write me an email and I'll give you the reference and then I'll tell you more or less what the court said in that case. But it is a problem.
I just want to find out the citations, please.
Yeah, I just know it's been there to ask them this somebody, but you can write me an email and I'll put it up for you. Or I'll reply. It's not something I would expect you to know for the exam or anything, but in case you run into a problem like that. So again, you see, it's because the Act doesn't make proper provision for what it says.
Just quickly, another problem we came across is there were provisional liquidators with extension of powers to trade. And it's a company that trades about 30 to 40 million a month. And right before month end, there was a business rescue application. And what does a liquidator then do? Because there's salaries to pay, there's insurance to pay, all that, but those powers are suspended. And it goes a bit further than merely saying, well, I'm staying my process, I'm still in office, but you still have to actively go and pay, disperse 40, 50 million rand.
I think the argument there is that continuing to run the business is not liquidation. It's not part of your liquidation process.
Yeah.
Your liquidation process is what you find in your final liquidation distribution account. In other words, what did you get in, what did you get for assets that were sold, or business sold as a running going concern, what did you pay, what were the dividends? That's your liquidation. The idea is that the duty of the liquidators at this point, I think, is to preserve the estate.
Yeah, so in
So
essence,
if running the business is necessary to preserve the estate, then I think you should be able to carry on. If the board doesn't like it, or the business rescue practitioner, or whatever future one, they can go to court, and then you can ask for a declaratory order to say, well, it's not liquidation. The Supreme Court of Appeal has now made it clear that the liquidators have not lost their appointment. They still have their authority. It's just that they cannot carry on with the liquidation process, and that would be because you don't want them to start selling off assets that you may need to rescue the business. Okay, I wonder maybe we should stick to this page. It's a tea time list, you know, I have to stay to go over time. No? Yeah, let's stay with this, and then afterwards, after tea or whatever, we'll carry on with the results or consequences. Okay, now, filing with the board resolution, that's easy enough. Court orders, I think we've dealt that, you've got all that in your prescribed material. The requirements, the first one, financial distress. I've mentioned some aspects of that. You will see that the definition of financial distress is phrased in the future tense, that it is unlikely that the company will be able to pay its debts within the next 6 months, or it is likely that the company will become insolvent, in other words, that the liabilities will exceed the assets within the next 6 months. So the question was, we know that the intention here was that we should encourage boards to start commence business rescue before the company is actually insolvent or unable to pay its debt. You wanted to do that when it sees trouble coming over the hill, to put the company into business rescue, because then you have a better chance of actually rescue the company into business. But then some courts originally, and the first few cases, said, look, this is future tense. A company that comes to court with a business rescue application that is already insolvent does not fall within the definition of financial distress, because the definition talks about future financial distress. If you're already insolvent, you're no longer in financial distress, you're just plain insolvent. You cannot go into business rescue and you must be liquidated. The Supreme Court of Appeal stepped in, OTIM case, and said that was our first Supreme Court of Appeal judgment in business rescue. You see, it's mentioned a few times in the textbook on various aspects. The Supreme Court of Appeal said no, that's not correct. A company that is commercially insolvent, in other words, it is already unable to pay its debts as they fall due, qualifies for both liquidation and business rescue. Depending on the second requirement, is there a reasonable prospect of rescue? So if the company is hopelessly insolvent, it can no longer be rescued, there is no prospect of rescue, then it's got to go into liquidation. On the other hand, if there is a prospect of rescue, then the fact that the company is already unable to pay its debts will not prevent it from going into liquidation, into business rescue, and we will allow the company to go into business rescue. Although it's already, strictly speaking, past the stage of financial distress. The other two requirements we've talked about, that's not a problem. There are other countries where they have the same thing about missing employment-related payments to that would be regarded as a sign of financial distress. But in those cases, they usually have a period. I think in Germany, it's like if you miss payments for 3 months or something like that. We don't have that. So if you miss it once, for whatever reason, they can somebody can apply for a business rescue order on the strength of the company missing those payments. Whatever the reason may be. Obviously, you'll be wasting your time and money if the company is not really in trouble. It's just something else that went wrong. But still, just missing one payment would already qualify you for a business rescue or business rescue application at least. The other thing is the prospect of rescue. There must be a reasonable prospect of rescue. Now you'll see that rescue in the Companies Act, or rescuing the company, is defined as meeting or achieving the aim or objectives or goal of business rescue as found in the definition of business rescue. And there you will find it right at the end of the definition where it says that you, if the company is in financial distress, then you can appoint a business rescue practitioner and he must draft a plan and with the aim or the goal of either returning this company to a solvent state, in other words, you rescue the company, so it's a corporate rescue, or if that is not possible, to pay a better dividend to your creditors or shareholders. Now, first of all, that would be the case in an immediate liquidation. Now, first of all, to say that you pay a better dividend to your shareholders is rubbish, because in a liquidation, you don't even have enough money to pay your creditors. So where would the money come from to pay your shareholders? Shareholders, you can really say never get any payment or dividend in an insolvent liquidation, because there's not enough money to go around. So I don't know why they add shareholders. Nobody else has that. It's fair. It's loosely based on the same provision in the English law, in British law, UK law, but they don't have the shareholders because it doesn't make sense. Okay. Now, although it doesn't talk about the rescue of the business, it simply says to rescue the company, or otherwise it's a better dividend for creditors than would be the case in an immediate liquidation. This is interpreted as meaning it's a rescue of the business or a part of the business that is viable. Because in theory, if you sell a business or part of a business as a going concern, you get a better price for it than you would get if you sell it in liquidation where you sell the assets. Now that, as I say, is just theory, because first of all, if there is a viable part of a business, even in liquidation, you will find that the liquidator will try to sell that part of the business as a going concern before the goodwill is all lost and the business loses its value, because his fees are based on the price you can get for the sale. So obviously he will do the best he can to get a good price. So if he can sell a business or the part of a business as a going concern, he'll do that, because that will give him a better fee as well. So it's in his own interest. Apart from that, business rescue practitioners and liquidators are very often the same people. They do both. So why would you sell the business as a going concern in business rescue but not in liquidation if it's possible? it's a theory. But anyway, so the theory is that you get a better price if you go into business rescue, you sell the business as a going concern, part of the business. So you rescue that business, so although the Act doesn't mention anything about rescuing the business, but you do rescue the business and you then get a better return or dividend for your creditors. Now, as I've said, this project that the University of Victoria did, they found that when they looked at the projected dividend, because when you apply for business rescue, when the company is in business rescue and you have to, as a business rescue practitioner, convince your creditors that there is a chance of a rescue and they must go to the plan, you must tell them what they will get, potentially, as payment in business rescue and what they will get in liquidation. And they found that the payments were very close to what was projected. And the payments in liquidation were slightly lower than the payments in business rescue, or the projected payments in business rescue. But as I've said, what we found was that some assets had disappeared in the meantime. So had those assets not disappeared and had the company been put into liquidation immediately, so they wouldn't have the costs of a business rescue practitioner and all the other costs, there would have been more money in the liquidation anyway, and your creditors would probably have received the same dividend or maybe slightly less than in business rescue. So it's a theory and it's not really applicable anymore. It used to be where liquidation meant you had an auction and you just sold off all the assets of the company, see what you can get. It's like a fire sale, as I call it, and then you just get all the money together of the various assets, and then you pay that as a dividend to creditors. But in modern times, first of all, companies do not have as many assets anymore as they used to have. A lot of companies have no assets. It's all intellectual property. It's all done by way of advisory companies, that sort of thing. So a lot of their value lies in people and in intellectual property. So it's not an asset in itself. It's an asset you can sell, but it's not an asset that you can easily sell at an auction. Also, I've seen, not long ago, I saw a notice in the newspaper of an auction that was going to be held of a company in business rescue. But if you didn't know this company was in business rescue, you would have thought it's a liquidation because they were selling heavy equipment, graders and forklifters and stuff. It's an auction of loose assets, but it's in business rescue. So you get a sale of loose assets in business rescue as well, and there's nothing to prevent that. So there is no real proof, I think, as yet that you always inevitably get a better price in a sale of assets or business in business rescue. There was one case where they did get a better price, and that was because the company had very specialized equipment. I think it was they quite oil from the Cape or something like that. So their equipment was highly specialized and there was a very small market for this equipment. So they put the company into business rescue because they said, if we sell all the assets at the same time, it's going to just make the price go down. So in business rescue, we sell it off slowly so that we don't flood the market because the market is so small, and then we'll get a better price. So in some cases you can, but you cannot assume that you will always get a better price for assets or the business as a going concern in business rescue than you would get in liquidation. But that is the theory behind the prospect for rescue for the second goal, in other words, the better dividend for creditors. Very few companies, as I've said, actually get rescued, corporations. About 77% of all cases get rescued as a corporation or are still in business 2 years afterwards. So it's not a very big percentage. In most cases, it's a sale back. Yes?
What is that percentage in other parts of the world with similar things? Are we sort of tracking behind, or is it?
It's very much the same. it's very much the same. Many years ago, 1997, an English academic wrote a book on business rescue, concentrating on the United Kingdom, but then he did some comparisons with South Africa's judicial management and America's Chapter 11 and so forth. And he said that South Africa's success rate of 5% actually compared very favorably to other countries. So it's in most countries it varies between 5 and 10%, depending on your definition of success. So if you regard the rescue of a company, of a corporation as success, then it's very low. If you regard just a sale or a rescue of a part of the business, a viable part of the business that you sell as a going concern, then it gets higher. But it's not all that high anyway. Okay, let's see, what else about prospective rescue? Okay, so the courts grappled with what is a reasonable prospect of rescue. It's not defined in the Act. I don't think you can define it because it will very much depend on the circumstances of each case. There was one case originally, which is mentioned in your textbook, Southern Palace case, where the court tried to come up with a sort of a checklist and said, well, if you want to convince me that there is a reasonable prospect of success, you have to tell me what went wrong. Why is this company in financial distress? Why did it go wrong? What are you going to do to rescue it or to turn around the situation? And where's the money going to come? But the court made the mistake of saying you must have a plan. So some commentators went a little bit berserk and said, does that mean you must now submit, file a business rescue plan, when you apply for business rescue, that's the job of the practitioner, and it comes much later, etc., etc. I don't think that's really what the judge meant. He just meant you must have some sort of a plan in your mind how you're going to fix this, because if the company is in financial distress, because there is no market for its products, nobody wants to buy this stuff, there's no way you can rescue this company, no matter what you do. If you can't sell your product, if there's no market for your product or it's low quality, you're not going to be able to rescue this company or sell the business. So you have to know what went wrong, why it went wrong, how you're going to change it, and how you're going to pay for it. Because the company is obviously in financial distress, it doesn't have the money to pay for improvements. It will have to get some post-committed finance. It will have to get finances from somebody else. And the problem is with that, who's going to then use amounts of money to a company that's already unable to pay its debts. In the United States, they apparently have some sort of a profitable business selling these, granting people to provide cash, provide finances, and in turn they either get shares, etc. And they say that Warren Buffett actually made a lot of money from that. But then you have to know what you're doing. You have to know whether this company is viable, or this business is viable. So it's risky, but it is sometimes done, and private equity firms in particular sometimes invest in that. Okay, we've talked about this notice. We've talked about the financial distress and the prospect of rescue. Basically, you'll see that the courts still, or not so much anymore, but originally referred to judicial management quite a lot, because in judicial management you had to prove that it was almost a certainty that this company will survive if you judicial management. So they wanted to make this differentiation that for business rescue, it's just got to be a reasonable prospect. You don't have to be, it doesn't have to be a probability, just a reasonable possibility. And they describe it in various ways. You'll find that in your textbook of it must be concrete, but we must put the bar too high, etc., just to get away from this very difficult requirement in judicial management. Right. Let me see, up to there, any questions, anything you want to talk about or comment or ask? Are you still okay with it? Yes?
Insofar as the procedure will apply to court for business rescue, should the process fail in court, does it automatically go into liquidation? Or
No.
is it a court's
No.
directive?
If it was already in liquidation before the application for business rescue, then the liquidation is only suspended, so it automatically comes back again, and the liquidation is just carried on. If it was not, it will depend on the person who asks, because if it was commenced by order of court and business rescue is not working out, then you have to apply to the court for an order to cancel, to terminate business rescue. And then it depends on the applicant. If the applicant asks for liquidation, which they usually do, and the court is satisfied that it's a good case for liquidation, then the court will order liquidation. So it will depend on each situation.
So it's not automatic.
It's not automatic, no. You actually have cases where the court refused liquidation order, although the business rescue didn't succeed. They terminated the business rescue before it had run its full course and would still not get liquidation. But that's usually on a technical point, like who's the right person, who has the authority to apply for this liquidation. Is it a business rescue practitioner or the board of directors or a creditor, etc. So it was usually on a technical point, but it's never automatic. Right, let me see what else I have to talk about now. I think we've covered the basics here. As I say, all the details are in the textbook, and what you don't find there, a little bit of extra information in the tutorial letter, but most of it is in the textbook. Right, so now we've had the procedure, we've had the application report, and we have the resolution that's filed. Now obviously, the business rescue commences immediately once this resolution has been filed. That's how it commences. In this case, it also commences, but it can be cancelled basically if the court refuses to. So it's a sort of a provisional, if you can call it that, commencement. But it's of course, as I said, only 10% of cases where you have that. In most cases, you have a resolution, and that immediately commences business rescue. The board appoints a business rescue practitioner, and then of course they have their notifications, which I don't think I have to talk to you about, because you're all now very familiar with the notification requirements and what happens if you don't follow the procedures, the procedure requirements, 129, 3 and 4. The tragedy about that for me is that before the Supreme Court of Appeal gave that judgment in the Panama case, the situation was more or less sorted out. Although the Act is not correct, because it's got conflicting provisions. It says the resolution lapses and is a nullity, but then in the very next section it says you can apply for the resolution to be set aside because the procedure requires it. You cannot set aside a resolution that's already a nullity. What you set aside. But just before the Panama case, the court had in fact more or less sorted it out by saying, okay, if it's about appointing the business rescue practitioner, then if you don't do that within the prescribed period, the resolution lapses. That's the. However, if it's about notification, as they explained in the Ex parte van den Steen case, the Act does make provision for substantial compliance with notification requirements. The Act actually says in Section 6, you don't have to comply 100%. If there is substantial compliance, then that's fine. So it had more or less sorted itself out, but then came the Supreme Court of Appeal, and first of all, amended the Act, which the courts are not supposed to do, because there's a very strict, in our Constitution, you have a very strict division between the judicial powers of the courts and the power of Parliament is the one making this. That's the legislative powers. It's in Parliament, and the role of the court is to interpret and apply the Act. They're not supposed to amend the Act unless it's the constitutional court which says something is unconstitutional, and then they can say you have to amend the act, but in the meantime, that's how we will interpret the act. But other courts are not really supposed to change an or to an and, which in law is a huge change to make to an and. They're not supposed to. But the courts apparently feel that they now have legislative powers because the act is faulty, effective, so they feel that they now have to do something to, which is what we saw in the Manuel's case as well, where the court has decided we'll appoint a manager because the act has no provision for who's in charge of the company while the liquidation proceedings are suspended. So we'll just think up something and apply that, which is really, really not allowed. The Supreme Court of Appeal was actually quite firm about the fact that we're not supposed to, the court is not supposed to create law to legislate. Their role is to adjudicate, in other words, to interpret the law and to apply the law and not to write them. Okay, now let's see, what else was there that I wanted to tell you, or needed to tell you? The problem with business rescue is that one of the goals was that with business rescue it should be much easier to commence than judicial management. So that's why they made it possible to commence business rescue by simply filing a more resolution. The idea was court sees there's trouble coming, they immediately start business rescue proceedings. It's easy to commence and then you will rescue the company and rescue jobs, etc. So they excluded the court except for specific cases. But the problem is that apart from the commencement, for everything else in Chapter 6, you have to go to court. If you want to have the resolution set aside, if you want to remove the practitioner, if you want to amend the plan, if you want to terminate the business rescue because it's not successful, for everything else, you have to go to court. And that is a bit because it's expensive and it takes a lot of time. Now, they are going to amend the Companies Act. Well, there's a bill out, so maybe it won't take too long. Where they are trying to give more powers to the tribunal. And if you ever have a problem, not just the business rescue, but anything else in the Companies Act, and you can somehow take it to the Companies Tribunal, I would strongly advise you to do that. First of all, it's much faster. You can get your answer or your decision within 3 to 4 weeks. Secondly, you have company law experts on that panel. So they actually know and understand corporate law in general and the Companies Act specifically. So your chances of getting the right decision there are much better than in a court. Because you have to remember, this act has only been in operation since May 2011. So it's almost exactly 8 years now. There isn't a single judge on the bench at the moment who ever studied this act. Now, as far as it repeats previous provisions or are similar, that's fine. But something like business rescue is completely new. They have never actually studied it actively. Nobody's ever explained it to them, nobody's ever told them how it works. They are self-taught, sometimes from questionable sources as far as I can see. So they don't actually, when you appear as a young counsel or attorney before the bench, you actually know more about the act than they do, because they have to study almost literally thousands of new legislation. The Companies Act is just a small part of it. So they've actually had to read through it and take it at face value or get some sort of interpretation that seems acceptable to them. But they have never been trained in this act. And that's part of our problem. In other countries, they actually take the judges on training courses when they have important new legislation. They don't do it here. Maybe our judges feel they don't do training. They can actually do it quite themselves. But you can see sometimes that they completely misunderstand something. And you get some very, very weird and wonderful judgments. So that's part of your problem. But the Companies Tribunal, they have actually got experts there. And they give you properly motivated written decisions that you can basically rely on like that. And much cheaper, it's faster and it's cheaper. So that's really the way I think to go. In the Gauteng Provincial Division of the High Court and in Johannesburg as well, I think those are the only two at the moment. They have actually created a sort of a separate part. They've sort of nominated a few judges to do specifically commercial work. And if you can then apply for your case to be heard by one of the judges, but you're still going to wait a long time because they are just flooded with cases. So your best bet, if at all possible, is go to the tribunal and you get an answer much faster. You don't have to wait a month and month to get a case on the roll and then wait for the date, etc. So the tribunal is, and they are going to expand the powers of the tribunal, I think specifically also with respect to business rescue, so that the tribunal can hear law cases and law conflicts and so on, so that there are more cases that can be taken to the tribunal, companies tribunal, so that the courts are not so overloaded with. Okay. Now, let me see, what else was there? I think that is basically what I want to tell you. You'll see in your tutorial related 102. I talk about the Janssen van Rensburg case where it all said the liquidators are still in charge of the estate of the company, though the liquidation has been suspended, and then I mentioned the two murderous cases to you. And the fact is that judge, the judge who gave the judgment in this case, is actually the same one who gave the judgment in the advance. Yes, it's the same judge. So he's actually given some very, very, very Fabricius says, he's given some really, really sensible, good judgments in business rescue cases, among other things. And then this one just went completely off the rails. Okay, let me see what else was there I needed to tell you. Okay, so just about regarding the prospect of rescue. Again, now I don't think you can define it. Some people criticize the act and say they should have given a definition of the prospect of rescue, but I don't think you can do that because cases differ so much. But one of the problems that we have there, still have to a certain extent, is that the courts do not agree on how much weight you should attach to the attitude of major creditors. So if you have a case, an application for business rescue, and there is a major creditor who's got 50%, 60% of the votes, or even 40%, because remember you need 75% of the votes to have your rescue plan approved. If this creditor says, I don't care what plan you come up with, I'm telling you, there's no prospect of rescue here, I don't believe in this business rescue, it's probably an abuse of the procedure, I'm going to vote against any plan you come up with, because there's no way you can come up with an acceptable plan. And here, in some judgments, you find the court said, well, that's why you vote as a creditor. You vote in your own interest to protect your own interest. If the plan is no good, or if the rescue is a waste of time and money, then you as a creditor have the right to say, I will not support this business rescue. I will not vote in favor of that. Others again say, no, you have to wait for the plan. You can't already say at the application stage, I'm going to vote against any plan. You have to be reasonable, you have to wait till you actually see a plan, and then you can decide how you want to vote and whether you want to vote against the plan or not. We'll get back to that because that is now again linked to the application to set aside an inappropriate vote. Because the question then is it inappropriate? When is it inappropriate to vote against the plan? But at this early stage, and you do find, because there is a lot of abuse, let's not be embarrassed about that. Business rescue is abused to a large extent. You'll see that in many cases in judgments where the courts also say, this is such a flagrant abuse of the process. It is so obvious that all you wanted to do was to stop the liquidation. That's usually the main reason. So what directors do is when the company is in liquidation and the liquidators start asking embarrassing questions about assets that have disappeared, payments that have been made, then they apply for business rescue because that immediately stops any section 417, 418 investigation into the company's activities. That is still under the 1973 Act. It's not that important to know, but for interest's sake, although the 1973 Act was repealed by the 2008 Act, Chapter 14 of the 1973 Act was not repealed. That's the one that deals with liquidations. So until such time as we get a new Insolvency Act, which will also cover insolvent liquidations, if you want to liquidate a company because it's insolvent, you have to use the old Act, Chapter 14. If it's solvent, if you want to liquidate it for other reasons, such as the shareholders are fighting or the directors don't agree on anything, but the company is still solvent, then you do it in terms of the 2008 Act. But if it's insolvent, if you liquidate a company because it cannot pay its debts, you use the old Act, Chapter 14. And in that Act, there is a provision for an investigation that you can do for if a company is liquidated because it cannot pay its debts. You can have a commission. The master of the Supreme Court usually does that, but he also sometimes appoints commissioners to do this investigation. It's an interrogation. You cannot refuse to come and answer questions. And then, so if the director sees this is starting to get a little bit hot here, then they apply for a business rescue, and then it stops or they hope it will stop this investigation. The other thing is that if a company is liquidated because it cannot pay its debts, there is a provision in Chapter 14 of the old Act, in terms of which you can hold directors personally liable for debts of the company if they engage in fraudulent trading. In other words, where they kept on trading knowing that the company will not be able to pay its debts, then you can hold them personally liable. That section does not apply to business rescue. There is, in fact, one judgment where the court said, oh, but of course it applies to business rescue. No, it doesn't. It's a chapter of the old Act only applies to insolvent liquidations. So they try to escape that personal liability risk. They try to escape the investigations or the interrogations. And so then they go into business rescue just to give themselves a little bit of time to work out some other plan. So there is a lot of abuse, and because it's so easy to commence business rescue, you simply file that resolution. Nobody checks whether you actually meet the requirements of financial distress and prospective rescue. It's only if somebody takes you to court and tries to get the resolution set aside because there is no prospective rescue, then you have to prove it. But otherwise, no questions asked. So they cannot really check with you. And as a result of that, there's a lot of abuse. We know that, we can see that in many cases that you go to court where somebody then applies for the resolution to be set aside, and you are really amazed at the plans and that some directors come up with too. So they do abuse this procedure. That is unfortunately a fact. Okay. So, let me see. That was basically most of what I wanted to say about the initial procedure. Okay, I've talked about the attitude of creditors. So creditors can see your bank of all people is usually your major creditor. They can see there's no way you can be rescued as a company. They can see you're in serious trouble, you've got far too many debts, and you are not going to, there's no prospect for rescue. So they can see there's abuse, but then if they say, you're against this and we're going to vote against this anyway, the question then is, as one judge said, well, that affects your prospect of rescue, because if you find a major creditor who's really got most of the votes, if he says, I'm going to vote against the plan, then you don't really have much of a prospect of rescue. But then the problem is that that vote can be set aside at a later stage. So that's the problem you have. But the judge in this case said, that affects your prospect of rescue. So you have to take that into consideration. Others say, no, that's unreasonable. If you're a reasonable creditor, you wait until you actually see the plan and then decide on whether to vote for But I think this is actually a good time to break for tea, although it's not, oh no, it's only 11:30 that we break. This is our, no, it is 11. It is 11. I'm just going to this is but I think I'm going to give you a tea break now so that you can just revive yourself, and then we will start again at a little bit after 11. Let's say 11:45. Think about this.
Is the business, you're saying business rescue commences as soon as that resolution has been ratified by the board?
No, the board, it's filed. That's filed. It must be filed. So the board takes the resolution and it files it, and the moment it's filed with the CRPC, business rescue.
I just want to be very clear on this.
Yeah. That's what the act, that's one point on which the act is actually. The moment it's filed. Okay, so let's have a tea break, and then I'll see you at
Uncle.
Hey, Dada.
Hi.
Sure.
Ukufamba njani?
Ah, shomba kahle Dada.
Yeah. Oh, did you also capture it? Okay.
Ngikarelo ngene wa.
Oh. Yeah.
Hey man, this class is got a lot of white guys. Okay, thanks.
Mara still white guy, vanilla.
Shungi maka. Ngikabo wetena.
Assignment voting got distributed. Oh, the outcome.
Amount would this all now.
Good sabo. Amana mfanelo ayimelana.
Nah, hey, accidents happened, man. Like, I'm much better now, in fact. Yo, I'm coming.
Oh.
But
Isapona.
Thanks, buddy.
Ja, dit is een van de grote dingen die eigenlijk mag jij zien. Nou, dus maar hij ziet wat het
Check that. Hey, Buzzer, stop with it.
Dit is geaccepteerd en niet zo wat we bijna voor afgehouden. Ganz viele met alles wat we doen. Daar kan je eigenlijk zien. het jy vir jare en jare die voorlopige liquidasie is op die einde. Dit kan tot op die einde van die before we start, I just want to introduce you to Ms. Magdalene Msoni. She's the one who does the administration of the course. So if you have any administrative queries like what happened to my assignment, or where do I get the tutorial letter, etc., yes, your go-to person. Anything you want to tell me? Do not ask me difficult questions.
You can ask anything.
Okay, so any administrative problems like, where to find those problems with my Unisa or stuff like that? Yes, the person who can assist you. Because remember, I'm not employed by Unisa, I have a contract with her. So I don't have access to all the inside information, inside systems. But Paul has, so she can help you with those things. Okay.
I believe some people were opposed to it, but there wasn't anything online. I don't think I received it.
No, there is no tutorial letter.
This is now. It's posted.
No.
It is now. It is there.
I
can't. It's under announcements.
On my Unisa.
Oh yeah, you go onto my Unisa. Then on the landing page, there's a heading on the right, announcements, and your most recent announcements are there. And that's why, so I put it under announcements, so you can immediately see there's a newest announcement. And then when you go to announcement, you can actually click on that and then it opens the tutorial for you. Or you can then go to announcements on the left, click on announcements, and they're all there, the 101, the 102, the 103, and something that you posted as well. Yeah, so it's all there. So it's always under announcements because they send you the message when there's an announcement, and you can immediately see on your landing page when you click onto my message, you immediately see, okay, here's a new announcement that I have.
I got tutorial on under assistance.
It's under announcements as well. Because I put everything under announcements and she puts it under resources. But mostly under announcements.
All the information will be posted under announcements.
Yeah. And that's where you will get your exam paper as well. Frankly, I don't know how to get onto resources. So you'll find your exam paper under announcements as well. But then you see it in the yeah. But if you have problems there, then
It's stay over. So that it's
Regarding, I have to go back to the office.
she's our anchor person actually.
You can contact me.
Yeah.
Yeah, because the email says it's all in one. Okay, anything you wanted to ask her before she answers?
Maybe just note that it's not all tutorial for 103. It says discussion of assignment 1 and learning to
Yeah, that's the heading. Yeah,
so you need to click on that and then the bottom it says.
Yeah, but it doesn't, it's just that, so that you will immediately see, this is the discussion of the assignment, this is what I want you to look at. Sometimes I'll just put something in the body of the announcement, but if it's something formal like a discussion of the announcement, I'll put in the tutorial letter and attach it. You can immediately see it under the Okay, so, are you all comfortable with this? Did you think of any other questions you wanted to ask here? Somebody asked me a question, so I thought we could just repeat this. The court order, any affected person can apply for a business rescue order. That means you must be a shareholder, a creditor, a registered trade union representing some employees in the company, or the employee themselves, or a representative of the employee. The company cannot apply, the directors cannot apply in that capacity, but directors are usually shareholders, very often also creditors, so in that capacity they can apply, but they cannot apply in their capacity as directors. Okay, so that's all very clear. Okay, now we've got business rescue, it has commenced, and so what are the consequences? The most important consequence, really, or the most important aspect, I suppose we should call it, of business rescue is the moratorium. Because that is really what business rescue is intended to achieve. You cannot really have a business rescue without a moratorium or a stay. So what this is intended to do is to give you, or to give the company a little bit of breathing space, just so that the creditors will stop harassing you and you have time to just plan and see how you are going to reorganize or restructure this company. So that's the most important thing. So unfortunately, again, bad drafting, I sound like I've only got one sentence to say, which is always it's bad drafting, that the section 133 that regulates the moratorium, again, not very well drafted, not very clear, and so we have the usual problems with conflicting judgments and so forth and so forth. So when you look at section 133, you'll see that it says, during business rescue proceedings, no legal proceeding, including enforcement action, against the company, or in relation to any property belonging to the company, or lawfully in its possession, may be commenced or proceeded with in any form, except, and then you have a few exceptions, very obvious exceptions like criminal proceedings, etc. So it's basically civil proceedings, and the idea is to give this company a little bit of breathing space, to protect it so that it has a little bit of time to come up with some sort of a plan to reorganize itself. Okay, so problems. First of all, it talks about no legal proceeding, including enforcement action. So, what does a legal proceeding include? Big debates again. And originally it was thought that cancellation of a contract would also be an enforcement or a legal proceeding. In other words, if an outsider cancels a contract with the company because of breach of contract, there was an argument that this would be a legal proceeding, and therefore you cannot do it. It is prevented by the moratorium. You'll see in the textbook there are one or two cases I mentioned there where the court actually said you can cancel a contract with the company in business rescue because it is prevented by the moratorium. However, again, the Supreme Court of Appeal stepped in and said, yes, you can, because cancellation of a contract is a juristic act. It's not a legal proceeding. A legal proceeding is something you do in a form, a legal forum. So you can cancel a contract with a company and you give back to contracts because that also creates all sorts of other problems. So that was the first problem. What is it included under legal proceeding? Okay, so now we know definitely not cancellation of contracts. So there's no moratorium or stay on cancellation of contracts. Then the next thing is that the moratorium says, or section 133(1) says against the company or the property of the company or other property lawfully in possession of the company. In other words, it's not the company's property, but it is other people's assets in lawful possession of the company. Unfortunately, it doesn't say at what stage it must be in the lawful possession of the company. Keep that in mind because we'll get back to that when we talk about contracts again. What would be legal possession, lawful possession? Then the next question was, what do they mean by a form? Because it says you cannot commence or continue with any legal proceeding against the company or in relation to any property belonging to the company or lawfully in its possession in any forum. So what would count as a forum? So there was one case where the court held that arbitration proceedings would not be subject to this moratorium or stay because arbitration does not take place in a forum. Again, the Supreme case went on appeal. The Supreme Court overturned this decision and said an arbitration can be made in order of court. So it is a legal proceeding and it is a forum. So arbitration, there is also a moratorium on arbitration. The next question was, what about proceedings in the labor court? The labor court is obviously a forum and it's a legal proceeding, but in section, one of the first sections, 1 or 5 or something of the Act, there is a list of legislation where it is said that if there is a conflict between the Companies Act and these pieces of legislation, then that other piece of legislation will prevail. And the Labour Relations Act is one of those acts. So it was argued that proceedings in the Labour Court will not be affected by the moratorium or stay because the Labour Relations Act supersedes the Companies Act. However, we have now seen that more and more decisions of the Labour Act, of the Labour Court, they have said that proceedings in the Labour Court are also subject to the stay because if a Labour Court, for instance, makes an order against the company, business rescue, that they have to pay their employees or something like that, then it has an effect on the financial situation and the reorganization of this company. So it is just as bad for a company to get an order against it in the Labour Court as it is in any other court. So it was held the Labour Court proceedings are also subject to the moratorium. What the court said was that when you look at the section that says that in case of a conflict, the Labour Relations Act prevails, it doesn't mean that it's not about the proceedings, it's about the provisions that you cannot take away the rights of your employees under the Labour Relations Act and use the Companies Act for that. But this is not the same thing, so there is no real conflict here. Their rights are not taken away, they still have those rights, but proceedings in the Labour Court are also subject to this moratorium. So that's another problem that at least they have sorted out. Okay. The other problem is that you will see the moratorium is not absolute. So it doesn't say you cannot under any circumstances continue or institute proceedings. It says you cannot institute or proceed with these legal proceedings unless, except with the written consent of the practitioner, which sometimes they do give because they want this matter to be over and settled, or with the leave of the court and in accordance with any terms the court considers suitable. So you can actually ask the court to lift the moratorium so that you can institute proceedings against the company or continue with your proceedings. So that then created another problem. Can you go to court with your proceeding and then as your first prayer in your application say, please please give me permission to continue with my legal procedures or to institute these proceedings. And number two, if you give me leave, I want an order that says the company must do business or whatever. Some courts said, no, you can't do that. You have to go to court first and ask permission to institute these proceedings and for the moratorium to be lifted. Then if the court said, yes, it's okay, you can do that, then you come with a new application to say, okay, and this is now to institute legal proceedings. You cannot do it at the same time in the same time. The unfortunate situation was that the first case in which this was decided, and I'm sure it's mentioned in your textbook, was where the other party didn't want any payment or something like that, or any action from it. That all they wanted was they wanted this company in Business Rescue to be compelled to give them information. And this was the one case where the court decided, no, you can't do the two at the same time, you have to act first, ask permission, which is really ridiculous because it wouldn't have made any difference to the company, it wouldn't have harmed the company. They just wanted this information, and so they lost the case, they didn't get the information. The situation is a little bit more complicated when the action is actually instituted, when the company will actually say something or do something. So the courts disagreed on this, as they so often do. Some of them said, no, you have to go to court first, ask for the moratorium to be lifted, stay, and then if you get that permission, then you go back to court again, and now your institution proceeds. Other judgments said, well, it's really a waste of costs and time, especially if you are already before the court. Let's say you've started liquidation proceedings, now the company has applied for business rescue, you want to continue with your liquidation. For you to now first stop everything there, come to court, ask for permission to continue with your proceedings, and then come back again, while everybody already knows, all the parties are already before the court, it's really a waste of cost. So in that case, when you're already before the court, you can do it all in one. You can just ask permission to carry on and then carry on. Then some courts actually eventually said, it will depend on the circumstances, because courts are not quite sure what to say. They say it will depend on the circumstances, because then they've got some moving. But this was actually, I think, the sensible approach. The court said, to be able to decide whether I must give the applicant permission to continue or to institute the proceedings, I actually need to know more about this case that he wants to institute and how strong his case is. If I have no idea what this case is about and how strong the case is, how can I decide whether I should allow this action to continue or to be instituted? So my decision on whether to allow the moratorium to be lifted will depend to a great extent on the strength of the case that this applicant wants to institute. So basically, it would be more sensible to have the two of them together. So I look at the application, I look at the case, see how strong it is, and then decide this is a waste of time, I'm not going to allow it, or it's a good case, I will allow it. There are good reasons to allow it to lift the moratorium and allow this action to continue. Recently in the Western Cape, there was one case where the court also sort of leaned to that interpretation, where the court said, well, in terms of our constitution, you must not limit or restrict the rights of people to approach the court. The Constitution says we've all got the right to approach the courts, right of access to the courts. And if you now say, no, you can't do it, you have to ask permission first, we are in fact restricting that access. So it will depend on the circumstances, but we are leaning towards the interpretation you can do both at the same time. So you ask for, as your first prayer, you ask for leave of the court to institute the action, and then number two is actually already the relief you are asking for. that's the moratorium. Let me just see, where did I deal with contracts? Was it under the moratorium or was it under? Yes, okay. It's this part of the provision that says that it's a moratorium on legal proceeding or equitable enforcement action against the company or a property lawfully in its possession. Now, at some point, some judge read this thing incorrectly, maybe it was late at night, and he missed this little part that said against the company or in relation to the company's property or property lawfully in its possession. And what you now find in a couple of cases is that the court held that if a contract with the company in business rescue has been lawfully cancelled, the company is no longer in lawful possession of that property. So they don't have to ask for permission to lift the stay. For instance, if the company rents a property and it stopped paying the rent, even before maybe commencement of business rescue or after, the other party, the owner of the property, has the right to cancel that contract. The moment that contract is cancelled, you are no longer in lawful possession of that property. That applies to everybody. Also to the company in business rescue, because remember, there is no stay on cancellation of the contract. So once the contract has been cancelled, you're no longer in lawful possession, so they can go to court, ask for eviction, for instance, if it's an immovable property, because you're no longer in lawful possession. The point is, the Act provides for three situations: any legal proceeding against the company, or the company's property, or company's property lawfully in the company's possession. They missed that first one, so it's actually wrong to say you always, under all circumstances, have to ask the court's permission, leave of the court for the stay to be lifted so that you can execute your legal proceedings. However, you will see in your tutorial letter in the study guide, I've mentioned quite a few cases where the court just missed this little bit about any proceedings against the company and just concentrated on lawful possession and said, well, you're no longer in lawful possession of the property, so the party who's asking for cancellation or eviction or whatever doesn't have to ask for the moratorium to be lifted because it doesn't apply. It does apply. It applies to any legal proceeding against the company. Okay, so that's how mistakes happen. And then once one court has made that mistake, then they all carry on and make the same mistake.
Doesn't the moratorium, to a sense, miss something in the sense that what I've seen is banks still have the right to contractually set off debits and credits in different accounts. So in essence, you've got a moratorium on property in lawful possession, but you've got a claim on the bank on one hand, and they've got a claim against yours, and you might want to use that money to fund your business rescue process. But contractually, they're entitled to set those amounts off, and I think they do it as a standard.
Section 133 says that set off is allowed.
Yeah, so in essence, you sort of, it's a benefit on the one hand, your moratorium on the property, but on the other hand, your claims are sort of still at risk.
You know, the moratorium in the end, you'll see later on when we talk about contracts again, the moratorium is not as effective as it should have been. In some countries, they actually provide for certain contracts that may be cancelled. So they include in the moratorium cancellation of contracts, for instance, for the provision of water, electricity, gas, other service providers. They are not allowed to cancel their contracts with the company. So that is also subject to the moratorium. But in our case, they didn't include cancellation of contract. And if you go on the wording of the section, that's correct. It doesn't include, because there's no way you can say cancellation of a contract is a legal proceeding. So they didn't try to include it. I don't know, maybe they intended to, I'm not sure. But it's definitely not included. So the court was correct in saying it doesn't include cancellation of a contract. But as you will see later on, the moratorium is not as effective as it could or should have been, really. The smaller creditors perhaps will save themselves the trouble of going to court to if your major creditors decide they're not going to wait for something to end, then there are fairly easy ways to get around. Yes.
Does the moratorium also cover transactions that happen after the commencement of business?
Okay, now remember the moratorium only covers legal proceedings in full. So in other words, it's a legal proceeding in a court or some other legal form. So it could be the High Court, the Supreme Court, Magistrates Court, Labour Court, arbitration, CCMA, all those, they all cover. But if it's not a legal proceeding,
It doesn't cover normal transaction.
no,
Normal business.
No.
Right to buy, credit, and then you don't pay, and then people cannot get possible.
unless they apply for the moratorium. But it's a total, it doesn't look at the date or the period of the transaction, it only looks at legal proceedings including enforcement. So for instance, if you instituted action against a company before business rescue and you, the sheriff went and he attached some property, now it's going to be sold in execution, and then business rescue happens, then he can't sell that property. You have to cancel the sale because that's a legal proceeding. So the whole process of, because that's enforcement, so the whole process of going to court and claiming and executing a judgment, etc., all of that is part of a legal proceeding. And all of that is subject to the state. Yeah. Yeah, SARS is really unhappy about it, but they, as you can imagine. But even they don't even have, you know, in insolvency law, the receiver of revenue has got preferential treatment, preference claim. It doesn't have any preference in business rescue. They tried, they went to court and tried to establish that they have certain preference rights and they're special creditors. Court said, sorry, business rescue doesn't provide for preference creditors. It's you're a concurrent creditor, or you're a secured creditor, or you're a subordinate creditor. That's it. And all of them are treated equally in your business rescue.
So including taxes that came into the books after commencement.
SARS has got its ways and means, many ways and means. So they have all sorts of ways in which they do try to enforce payments. The problem with SARS is that in terms of the Income Tax Act, the receiver of revenue or commissioner of revenue is not allowed to compromise payments. So you cannot come to an agreement with somebody who owes you taxes, okay, you could pay me 50 cents in your rand. But they are bound by the business rescue plan. But when we talk about compromises in terms of section 155, the SARS is not allowed to enter into a compromise with the taxpayer because the Act very specifically says SARS cannot compromise its claims. But the business rescue plan, specifically the Act says all creditors are bound by the plan once it's approved. So that's why SARS doesn't like business rescue.
Okay, so now those are the terms that came after the plan. No, not the plan. During business rescue. Commencement may be seen June. They submit the returning programs. SARS cannot apply for state payments.
Unless they go to court and ask for the moratorium to be lifted. Yeah. But now you have to remember that the idea is really that debts that arise after business rescue, they are treated differently to debts that existed at the moment. And they're starting to mix up these claims, but originally there was a very definite separation between pre-commencement and post-commencement.
Thank you.
Okay, so you'll see in your tutorial later I mentioned the case, for instance, Kipera Court. The Coast Corporation was already in arrears with its rental payments, and then after commencement it also didn't make any payments. So the lessor cancelled the lease agreement, notified the lessee he's got the company or the Coast Corporation he's got 7 days to vacate the property. And they didn't. They said, no, this is not true. You can do nothing to us. And the court said, well, you know what? the agreement had been validly cancelled. We still have that Supreme Court of Appeal case of, what's his name? Peter Mariko, I'm not sure what's his name was. That was his case that went to the appeal court where the Supreme Court of Appeal said cancellation of a contract is allowed in business rescue because it's not a legal proceeding. So the court said it was validly cancelled, and that means once a lease contract has been cancelled, the lessee is no longer in lawful possession. So you've got to go. And this was one of the cases where the court said, well, the moratorium on legal proceedings did not apply, and it was unnecessary for the applicant to seek the leave of the court to institute the proceedings. And so the court gave a mediation order. And that's wrong, because it's a legal proceeding against the company or property lawfully instituted. So the moratorium applies to all legal proceedings. The court would in any case have given its permission to lift the moratorium. So in the end, it didn't make a difference to the end result, but it was wrong to say we don't need to ask for a moratorium to lift it. And everybody is very calm about this and very happy not to ask it. And then one day, one judge is going to look at the section again and say, hey, wait a minute. The Act talks about any legal proceeding against the company. Why didn't you ask for permission? And now I'm not going to give you your relief because you didn't ask for one. So it's better to ask. Even if the courts tell you it's not necessary. In J Logistics, again, here the company had bought a vehicle under an installment seller transaction. The bank cancelled the agreement when the company fell into arrears. They obtained a court order confirming cancellation, ordered the return of the vehicle, and then the company was placed in business rescue. So sometimes the company said, well, we'll just go into business rescue now, and then it's enforcement action. They can't come and take their vehicles. And the court said, no, sorry, you're no longer in lawful possession of these vehicles, so they have to go. Right. Again, the court said the moratorium doesn't apply, which was wrong. Now, the tragic case I mentioned was the Elias Mechanicals Building and Civil Engineering contracts versus Stego. Here, the court actually said the complete opposite and said you must first obtain my permission or my leave to institute proceedings, and then you can institute proceedings. And this was the one case where they just wanted information, they just wanted nothing more. And it was refused because they didn't ask for permission. Right. And then, Safari Thatching, that's where the liquidation application was already going on. So the court said, well, it would be silly for me to ask you, tell you you have to ask for permission in a separate application and continue, because everybody's already here. You can just as well ask now and then get it over and done with and carry on. BP Southern Africa versus Intertrans, I think that was probably the most sensible of the lot, which said that the prospects of the application for leave would depend to a large extent on answering stronger cases. So, rationally, reasonably, you should have the two together so that you can decide if it's a good idea to grant leave. Then, let's see, I've mentioned that in Chetty, the Chetty case where the High Court said arbitration proceedings are not covered, and then the Supreme Court of Appeal said, no, they are, because it's a forum. It doesn't have to be a court, it's a forum, and you can actually make an arbitration award court order, so it's a legal proceeding. So that would also be covered by the moratorium. I've mentioned the cases of the Labour Court, and you can see that the later cases all say the Labour Court the Labour Court is also subject to proceedings in the Labour Court, are also subject to the moratorium, so you also need leave there. And then very interestingly, in the Shiva uranium case, I think it's also one of the Gupta companies, but I'm not really sure. There was an application made to the Labour Court by employees of the company for leave to institute proceedings against Shiva uranium for payment of all their unpaid remuneration. And the Labour Court said that in section 128(1)(e), the Act defines defines court as the High Court. So the Labour Court does not have the necessary authority or jurisdiction to lift the moratorium. It has to go to the High Court. The Labour Court doesn't have it. It's not a court for purposes of business. Okay, let me see. That's the moratorium. Then, protection of property interests. So, we've got all the problems here with what the meaning was, etc. But that's all in your notes at the textbook. The next one is protection of property interests. Now, I have to tell you that you'll see this is not a very effective provision as far as the company is concerned. It doesn't really come to much. It's a long provision, but in practice it doesn't mean very much. Because, just see. The Companies Act provides in normal circumstances. In other words, where a company is not in business rescue, it applies to all companies. If a company wants to sell all or most of its assets or business, it must get permission by special resolution of all its shareholders. Now, it isn't clear in the business rescue procedures in Chapter 6 whether that applies as well. It seems to be the case because when you look at section 134 of the Act, which is the one, protection of debtors and property interests, it says, during a company's business rescue proceedings, the company may dispose or agree to dispose of property only in the ordinary course of its business. Now, selling off all or most of your business or assets, that would not be ordinary course. In a bona fide transaction at arm's length for fair value approved in advance and in writing by the practitioner. Now that is not clear. At arm's length, bona fide transaction, so if you sell off most or all of the assets, is that bona fide? I would think not. I would think it would be smaller transaction. It would not be one of these where you sell all or most of the assets or the business. For that, you would still need the approval of the shareholders until your business rescue plan has been approved. Because the third exception is in a transaction contemplated within and undertaken as part of the implementation of a business rescue plan that has been approved. So if it's in your business rescue plan, you can sell off whatever you want. But if it's not in the business rescue plan, must be ordinary course of business, or the business rescue practitioner must give his written approval. So I think that's the sale of all or most of the assets or business would still be covered by section 112 that requires the approval by shareholders until you get to the point where the business rescue plan is approved, and then it doesn't matter. What section 134 also says is, okay, if you as an outsider, if you're in lawful possession of the company's property, you can keep it unless the company, for certain reasons, reclaims it. And then, no person may exercise any right in respect of any property in the lawful possession of the company, except to the extent that the practitioner consents in writing. But now you've seen that the moment somebody cancels the agreement in terms of which the company had lawful possession, the company no longer has lawful possession. So this offers very little. It's very easy to turn lawful possession into unlawful possession. And unfortunately, the Act doesn't say if the company is in lawful possession at commencement of business rescue, it stays in lawful possession. You can't change that. You can. You cancel the agreement. If there is breach of contract, if you have grounds for cancellation, then all of a sudden lawful possession becomes unlawful possession and you can take it back. So this section, this subsection means very little. Because it would always be in terms of a contract that the company has the property of other people in its practitioner may not unreasonably withhold consent for someone to use his property, but as I say, it's anyway, so it's not really an issue. The only one that actually gives any protection, not to the company, but to the outsider, is if during a company's business rescue proceedings, the company wishes to dispose of any property over which another person has any security or title interest. Now, the phrase or the words title interest, we don't use that in South Africa. We have no idea what that means. So we know security. If somebody has rights, the rights we know are the rights of a person who has security. In other words, a bond registered over the company's property, a notarial bond or lien or whatever. We know what that is, but title interest we don't know. Because if you have title to property, you're the owner. If somebody else has title interest, he's the owner. We don't know this. You can't have title interest over somebody else's property. That's not. Okay, so but then it says, and some courts said, we'll just ignore this two words, title interest, we'll just go with security over property of the company. If the company wants to sell that property, it must get the permission or consent of the person holding that security before it can sell that property. Unless the proceeds of that sale will be enough to pay off the security. So let's say it's a property of the company, the bank has a bond registered over this property. If the company wants to sell this property, it must either get the bank's permission, which the bank won't give unless it gets some sort of a guarantee will be paid, unless the proceeds of the property will be enough to pay off that security. Then you don't do it. So at least that's one piece of protection for creditors holding security over property of the company. Now, there was one case where the court actually tried to interpret title interest. What happened here was that the company leased property. It wasn't a movable property, it was a equipment or something. It leased it, and then there was a retention of title by the owner of the property, the leasehold, which said, in other words, the company leases it, and after a certain period, it will become the owner, but there was a retention of ownership. So the court said this is a case where there is a title interest, because the original seller or lessor of this property still had a title, it still had basically property rights over this equipment. Because what happened here was that the business rescue practitioner sold this equipment, didn't ask for permission from the owner of the property, the seller, and then when the seller found out about this and wanted to be paid or at least get his property back, the action, he instituted action against the purchaser of this property. So you have to be very careful when you buy something from a company in business rescue. The original owner reclaimed his property or paid it, and then the new owner said, but I paid more than the amount that the company still owed you for this equipment. So the court said, well, that doesn't help because the business rescue practitioner didn't pay it over to the owner. The business rescue practitioner kept the money in the company. So that argument just doesn't work. The idea is not just that you must get more or at least what is owed, that money must go to the person who has this title interest. And the court described this as the title interest. But it's basically just that you are still the owner. But that eventually the company would have become the owner if it had paid for now. So, but the argument is that, but I paid more than the amount still owing. So basically, then it doesn't apply anymore. The court said, no, of course it applies because that money is supposed to go to the owner who holds this title interest, who was still the owner of the property because of the retention of title. So that, at least in that case, it protected the outsider. Okay, then, let's see what was the next point. Commencement Finance, or PCF. Now, you remember that I said in that Southern Palace case, the court said, if you can't show me that you've got money to reorganize this company and rescue the company, you can't get prospect and rescue because you're going to need money and you obviously don't have money yourself anymore. Now, it's a worldwide problem. Most companies in some sort of reorganization or corporate rescue, business rescue, whatever, have a problem in getting funds for obvious reasons. You can't issue shares anymore. Nobody can buy those shares. If you can get an existing shareholder who believes it's worthwhile investing more money, that's one source. Otherwise, you have to go to your bank, to whom you already owe so much money that they don't pay anything. So your chances of successfully, and in most cases, the company doesn't have secured property anymore. All the property of the company is probably already secured to the youth with bonds and liens and whatever else that you've got. So it is a problem. It cannot really provide security, and creditors are not very keen to provide post-commitment finance. So in most cases you find that if they do get post-commencement finance, it's usually from the existing creditor who believes that if he gives more money, then maybe this company can be rescued and then you can get your money back. One American commentator defined post-commencement finance as saying to somebody, hey, let's lend large amounts of money to a bankrupt company. Because that's basically what you do. You're giving money or lending money to a company that cannot pay its debts. So it is risky. As I said, in the United States, they make a business out of this. But then you have to know what you're doing. You have to know which companies have a good possibility of being rescued. But because of these problems, Section 135 of the Act tries to make it a bit more attractive for people to provide post-commencement finance. In your study guide, I mentioned the UNCITRAL legislative guide on insolvency, where they said to encourage people to invest or to give you post-commencement finance, because you usually cannot give them security, you already cannot pay your debts, you have to give them some benefit. And the only benefit you can really give them is to give them a preferred right to repay. So in other words, you push them to the front of the queue, closer to the front of the queue, than any other creditors, although they are unsecured creditors. Again, guess what I'm going to say? Bad drafting. So this gave rise to huge amount of problems. What Section 135 basically says is that your post-commencement providers, or lenders of post-commencement finance, they get preference rights above all unsecured creditors of the company. So it doesn't matter whether they are pre-commencement creditors or post-commencement creditors. And it doesn't matter whether the post-commencement lender is secured or not, he jumps to the queue in front of him. However, first in the queue is the business rescue practitioner for his fees and costs, and we'll get back to that when we talk about the business rescue practitioner. Then comes employees for all payments due to them after commencement of business rescue. Now, when we talk about employees, later on you will see that you are not allowed to amend their contracts anyway. So they have a preference right for salary, for leave, bonuses, anything you owe them in terms of their employment contract, they have a preference right for that. Then you get your post-commencement lenders, and then you get your current creditors. The Act doesn't say, first of all, it doesn't make a distinction between secured and unsecured post-commencement lenders. So now it's not clear. In our law, it has always been a very strong principle. If you've got security, you're first in line. That asset over which you hold security in liquid liquidation or insolvency, that asset gets sold, certain costs related to that asset may be paid from the proceeds. The rest goes to the creditor who holds the security. And only if he's been paid in full and there's some money left, then it can go into the rest of the estate. But otherwise, nobody else gets any of that money. Now, in section 135, the Act says that the providers, the lenders of post-commencement finance, will get the preference rights in above all unsecured creditors. And it says whether they are secured or not secured. Now it's not clear. Do you still put the secured post-commencement lenders above the unsecured ones, or are they on the same level? Because it says it will, they will have preference in the order in which they were incurred. Now let's say you have a post-commencement lender, you don't have any assets to use as security, so it's an unsecured loan. Then some or other asset or creditor abandons his claim or whatever, so now all of a sudden you have an asset that used to be subject to security that is no longer secure, that is no longer subject to security. Now you are able to give the second lender security for his loan. Does he now fall into the queue after the unsecured one because it's in the order in which they were incurred? That's what the Act says. So that common law principle, which has always applied in our law, that secured creditors go to the front of the line no matter what. Has this now been changed in this instance so that you strictly go chronologically? Unsecured, secured, unsecured, secured. Doesn't matter whether you're secured or not, it's strictly chronological, because strictly speaking, that is what the Act says. Which would be completely in contradiction of our principles. So there are two cases. I think I mentioned it in my tutorial. I try not to. I decided I mustn't mention them because they are so blatantly wrong. I don't even want you to know them. And then the other day I read an article in the Day and Day, which was written by two attorneys, in which they referred to these two cases as authority. So I thought, let me just tell you about these cases and then tell you they're wrong, so that you don't do the same. These two cases were decided by the same judge within a month of each other. The two judgments are almost identical. He copied and pasted the one into the other. And he missed this point that section 135 says that all these people with preference rights will have preference over all unsecured creditors of the company. And he said that these post-commencement lenders will also have a preference over secured recommencement creditors. In other words, creditors who had security before commencement of business, which is not what the Act says. It very specifically says unsecured creditors. So that is very clearly wrong, because that's not what the Act says. The Act doesn't even talk about pre-commencement secured creditors at all. So we now have a Supreme Court of Appeal judgment in which the court actually said pre-commencement security, those creditors, that company goes into insolvency or liquidation really, the old principles apply. Section 135 only applies during business risk. But in liquidation, we go to our insolvency law principles. In terms of that, you cannot use the proceeds of a secured asset to pay other creditors. The Act is very clear about what you may pay out of those proceeds, but you cannot pay other creditors. So among other things, you cannot pay the business risk recognition fees. In fact, to get later on, because that caused a great deal of consternation among business risk practitioners, because they thought on the so-called super, which put them first in line just behind the liquidation in case of liquidation, and that's not true. That's not correct. Well, it was never correct, but somebody just took example of the same right, so section 135 as an attempt to make post-commencement finance more attractive has basically failed. Firstly, because employee claims are put first before them, and with no limits. In insolvency, the claims of employees are very strictly limited. You can get X rand and salary for 3 months, etc. There are very strict limitations. In business rescue, there's no limit. So anything that is owed to them for whatever reason, for whatever period, how much it is, whatever, they have a claim for that full amount. So they could take on all the money that's available after security creditors have been paid for those claims. So it's not really attractive either.
Prof, regarding the preferential rights, so the legal practitioners' fees will be are the concurrent creditors or are they?
Yes, that's what the Supreme Court, that's where all the unhappiness came. Because the court said during business rescue, the business rescue practitioner can pay himself first, because that's what Section 135 says. But if they don't, and the company goes into liquidation, they become concurrent creditors, but with a preference. So they cannot be paid from secured assets. The liquidator can get part of the fees from the proceeds of secured assets, and not a business rescue practitioner. They're concurrent creditors. They have to be paid from the free residue in an insolvency state, and they have to prove a claim for their fees. That might be very
But I want to make reference to attorney's fees, because I mean, usually.
Same, because in the same Diener case, the attorneys who handled they did some work for the business rescue practitioner, I think, but they also applied for the liquidation on his behalf. And the court said, you are concurrent creditors, the Act doesn't make provision for any preference for you. It makes provision for the costs of business rescue paid by the business rescue practitioner. But your claim, you have to prove your claim and you're a concurrent creditor. And they didn't prove their claim, so they got nothing. I think there wasn't much in them. So they don't have the preference rights. However, you will see when we get to business rescue practitioners, the Act says that the business rescue practitioner, his preference right during business rescue includes the costs, his costs. So if he pays, and there is a case, one of them, the president of the TMA, is it McDuff? No, somebody else. Anyway, it's a case in your he appointed auditors and other consultants to assist him in a big business rescue. And then and he paid them. And then when the company went into liquidation, the liquidators said, this payment, no, I think he didn't pay them, but they claimed, or you claimed it as part of his cost. The liquidator said, no, you cannot pay other people for work that you as a business rescue practitioner have to do yourself. You're supposed to draw up financial statements and make projections and all this stuff and try and untangle the mess that the company is in. You cannot pay other people to do it. So the court said, no, that's not correct. And you cannot expect a business rescue practitioner to do every single thing himself. So he or she can appoint experts, especially when it's a complicated case. You can appoint those people because in this case the books apparently were a mess, you couldn't see what was going on. So the court said, well, in such a case, you can, because you cannot expect the business rescue practitioner to do everything himself. So he can appoint experts like auditors, like consultants, whatever else, to do some of the work for him, and that will be included in his costs. So he can do that. And it will depend on the circumstances, whether it was what was reasonable. So if it's a plain, simple business rescue, and you appoint all your friends as consultants and auditors and whatever else, that would not be reasonable. But if it's reasonable under the circumstances, you can do that as a business rescue practitioner, and that forms part of your cost, so it will also have preference rights that the business rescue practitioner has for his fees and costs. Okay, so post-commencement finance is a bit of a mess. It's going to become an even greater mess because there is a company's amendment bill which has now been published. If I go through chapter 6, I can point out about 100 mistakes that should fix. Not one of them has been addressed in the amendment. What they have done is to give a preference right to property owners for rental payable to them during business season. Now, first of all, your first question is why must property owners be singled out for this very special treatment? What about other suppliers, vendors? Why don't they get this special treatment? It makes it extremely complicated, so you can expect a lot more cases once this amendment goes through. Everybody has objected, but the DTI has a certain way of treating objections, which is to ignore. So it makes life much easier. So it will probably go through. They're having a workshop next week on the Amendment Act, but I don't really foresee that it's going to change a lot, and it's going to make Section 155 complete chaos. So expect new cases, but it will take some time before it comes. But it will make it much more complicated than it is now. What I want you to notice in Section 135 is when they talk about the providers of post-commencement finance, they don't call them creditors, they call them lenders. My view has always been that the reason why they don't call them creditors is because your definition of affected persons includes creditors. And most of us have always understood that to mean people who are creditors of the company at the moment of commencement of business research. The people coming afterwards are not called creditors because they are treated differently. They are not included in your business research plan. Sometimes now they are, because nobody really knows what the situation, the current situation is, because the Act is not very clear. But it must mean something that the Act does not call them creditors, but calls them lenders. So we'll see how that goes, but and it will probably have to be sorted out anyway if this Amendment Act goes through. So then we'll see what the interpretation is going to be. Because of course, once they are creditors, post-commencement lenders, then that means they must have a vote because creditors have a vote on the plan. So your voters get more and more. The numbers grow bigger as the company goes on into business rescue. Because the lenders and the other people, the employees who are owed money, the numbers rise and the amounts. So they will have more and more voters and bigger and bigger votes. Right, so that would be post-commencement finance. You see that I've put the list of preferences in your state right, but that applies during the business review, and that's what the court also said. These preferences apply during business review. Once the company goes into liquidation, it's a different ballgame. Now you're subject to the Insolvency Act, and this is how it goes. Okay. And that case is also in your, right, so that's what we have with post-commencement. Now we get to contracts. Actually, before I get to contracts, I should perhaps just mention one of the very specific provisions in the Act regarding employees is that business rescue does not affect in any way the contracts, the employment contracts of the employee. So you cannot use business rescue to fire some of your employees or to do retrenchment as a shortcut. If you want to do retrenchments, and in most business rescue cases you will find when the business rescue practitioner is appointed, when he starts investigating, he very often finds that payroll is a very, very big part of the company's financial burden. So very often it is necessary to do retrenchments, especially if there are parts of the business that are just not profitable. So in an effort to cut off the non-profitable bits of the company or the company's business, retrenchments are almost inevitable in any business risk, because that's one of your biggest savings if you can reduce your number of employees. The business rescue provisions do not make it any easier. You have to follow the full procedure of the Labour Relations Act as if this is a solvent, healthy company. So you have to go through the whole process of consultations. Your employees may strike if you employ more than 50. Everything. They have all the rights that they usually have under the Labour Relations Act, and you cannot use your business rescue to retrench them. You have to use the normal procedure that any solvent company has to use. Which of course means, as I've said before, that all benefits arising from your employment contracts, like bonuses, leave credits that must be paid out, commission, anything like that, your employees are entitled to that in business rescue because you may not amend the employment contract, you also may not cancel. Right, so the effect of business rescue is that the business rescue practitioner may suspend any obligation of the company arising from a contract that was entered into before commencement of the business rescue, except employment contracts. We will not suspend any obligation. Now, it sounds in theory like a very strong form of assistance to the business rescue practitioner. So he says to some creditors, okay, I'm not going to pay you. This is a contractual obligation arising from before business rescue, but we're trying to save money or just get ourselves sorted out. So I'm going to suspend the obligation in terms of this contract. Originally, this provision said you can also cancel any obligation, but there was a lot of objections to that, so in the end they changed that. The business rescue practitioner can suspend an obligation, but if you want to cancel a contractual obligation, you have to go to court. And this only applies to contracts entered into before business rescue contracts. And then, of course, with the exception of employment contracts, you cannot touch those, and neither can a court. Okay, so it sounds like a good idea, because then if you can suspend this obligation, this contractual obligation, you can save a little bit of money. However, as you have seen, if the company breaches the contract, then the other party can cancel that contract, also in business rescue, and then reclaim their property, if there's property, because the company is no longer in lawful possession. However, if the company is not in breach of contract, and the practitioner now suspends obligations, let's say payment for a rental property, then strictly speaking, this is not breach of contract because he is exercising a statutory right. So if the company was not in breach of contract before, which would be grounds for cancellation, suspension of the obligation in terms of the Act is not a breach of contract. It's just exercising a statutory right, which sounds very good because then it means that the company, the contract cannot be cancelled, but the company cannot be forced to pay. Not so, because the court has now held that if this obligation is tied to a reciprocal obligation on the part of the other person, the other contract party. In other words, in a rental property, the company rents the property and has to pay rent. If the business rescue practitioner now suspends payment of the rent, then the owner of the property no longer has the reciprocal obligation to allow the company to use his property, because these two are linked. You pay and then you can use my property. You don't pay, you can't use my property. Which means that although it's not breach of contract, the owner of the property can still get an eviction order based on the fact that this is a reciprocal obligation. You do the one and then I do the other, they tie to each other, they feed each other. So even though it's not breach of contract, you can still get an eviction order. You don't cancel the contract, you just say, I get the eviction order because of the reciprocity, the principle of reciprocity. So it's one obligation in return for another. If the one party doesn't deliver on his obligation, the other party, on the basis of reciprocity, is not obliged to deliver his part either. So if it's a immovable property, the owner can get an eviction order. If it's, let's say, vehicles or heavy equipment, the owner can say, I want my property back because there's no reciprocity, you are not fulfilling the obligations. So even though it's not a breach of contract, because of the reciprocity, you can get it back. Those of you who are lawyers will know about the exceptio non-ademplanti contractus, which is what you can, it's an exception you can use in an action where the other party says you must now perform in terms of your contract obligations, then you can say, but my defense is you didn't perform your obligations either. So if you suspend, I can suspend my obligations as well, because the two are linked. It's reciprocal performances, and so although it's not technically strictly speaking breach of contract, I can still get my property back, which comes from the same thing, basically. So it doesn't really help much. The suspension of contractual obligations is of very, very little use now.
Was the court decision proper ECA judgment, or was it just a High Court judgment?
High Court. It's in
Because
law.
it sounds also wrong. I mean, if the intention of the legislature was to protect the moratorium.
Yes, but you see, once again, the Act doesn't say whether it sort of amends the common law. And in terms of our interpretation of law, you can only change the common law as far as is necessary. So you have to be actually very clear in an Act if you are amending the common law. And the Act doesn't say anything about it. So the court said, well, then the common law principles will apply. So it's reciprocal, and most contracts would fall under that. That you give something and then the other party has to give something back. Or you perform something and that person has to perform something. So if you don't pay the rent, then I'm under no obligation to make my property available to you. So I can get the eviction order or claim my movable property, my heavy equipment. Yes.
What happens in respect of contract for, instance, a project or completion of a project?
Of what?
Or completion of a project, for instance, say for construction in the construction industry. However, the BRP doesn't have financing to complete the project. However, the time is the project to be completed. I'm sure that the BRP cannot sustain the obligation in respect of that.
He can, but it's not going to help him very much to suspend his obligation, because he also wants to complete the transaction so that he can repay it. And in cases like that, where you actually need this company to continue, that's when you would probably provide post-commencement finance. An interesting case was at the University of Pretoria. They built a huge art gallery, the bridge across the road, very, very grand. And then the builder went insolvent. The builder of that construction was about, I don't know, halfway through, just over half. And in the end, the university provided money to the company to finish the project, because they couldn't hand it to somebody else at this stage. I don't know whether they were in business rescue or insolvent or what, but anyway, so if they were put into business rescue, for instance, that's where you would, so that they would capitalize this project so that the building could be completed. So that's what probably would happen in practice. Is that they would provide just enough so that they can continue the project.
If the landlord allows the company in distress to continue renting, but they're not making the payments, is that seen as post-commitment finance then?
That is actually one of the debates. What is included under post-commencement finance? And I think the courts have sort of decided that only money is post-commencement finance. I think that was what they held in, it was in the Dina case, where the court said it is clear, yes, when they talked about the super preference of the business rescue practitioner fees. So the argument was what is included in post-commencement finance. And the court said we see post-commencement finance as providing capital. It's not providing services for which you have to be paid, etc. That makes you a creditor, a claim, whatever. But it's not really post-commencement finance. There was another case, oh yes, that's the one that gave rise to this very strange Amendment Act. The Property Owners Association went to court and they argued, the case is somewhere in there, they argued that rental payments, that's part of your administrative costs. It's part of the costs of business risk. The court said, no, it is. Why would rent payments specifically be post-commencement finance, but not the other claims of people against the company? And that's what they're now trying to do. So somebody in the Property Owners Association has got really strong influences because they are actually now going to make rent payments specifically. They are going to give them preference as it's first. But the Supreme Court will actually say it's not. It's not post-commencement finance. Post-commencement finance envisages that you give capital to the company so that it can continue. Because people have been trying to argue for everything that should be regarded as post-commencement finance so they can get that preference right for mainly especially if the company goes into liquidation. So they've been saying rental payments and water and electricity and equipment and parts you need in a company to construct or build something. And the court has actually now made it clear that no, I think it was in the Sapara case where the court said no, post-commencement finance really is money give to the company so that it can continue its business and perhaps rescue itself for the business.
How would you handle a lease or maybe, let's say, a sales contract where the company then pays off half of the equipment and then goes into business rescue? The owner, which in the contract says it's still the owner until fully paid, can that owner then come back to the equipment? Even if it's maybe of cardinal interest for the company to carry on business eventually to be able to be business rescue.
Yeah, that's why I say I don't really see it depending on what the Amendment Act is, because it talks about property, so it's not quite clear when they are only talking about immovable or something. But on the basis of previous judgments, if the company doesn't pay, it's in breach of contract, and that's what that one case said, that's title interest where there's retention of ownership until the full amount to be paid, like in higher purchase agreements as well, installment sales and all. So there's a retention of title, it's a title interest, so you can claim it back. If they're in breach of contract. Otherwise, if they suspend it, then you can say, well, you have to pay me to get the use of my equipment because I'm still the owner. If you don't pay the reciprocity, then I take my stuff back.
So that even applies to the half that you pay, because surely the company has some sort of right.
Depending on the provisions of the contract. So the logical thing would be, even for the owner, would be to come to some sort of agreement with the company and say, okay, you've paid half, so what are the most important pieces of equipment you need to keep, and let's work out the value of that, let you keep that, and for the rest, if you need that, what sort of security can you give? Because you already basically have security because you're still the owner, but you're not getting any income from your equipment. So then that would have to be sort of done by agreement. But if the owner takes a hard line, he can say, my contract says I remain the owner of everything until you pay the full price. I want everything back.
Is there a concurrent claim from the company towards the provider company?
For
Because
what
of
they've
half
already
pay?
paid, no, because it's breach of contract. You see, that's what the contract. If a contract says, "And we use everything we've already paid," that's then what happens.
It's the same on the JPG logistics. The bank took back the car because the company couldn't afford the car. The judgment in JPG logistics, it was the same because the bank took back the car. Yeah, I'm just commenting on what.
Yeah, so and the bank took it back.
Yeah.
Because they said it's breach of contract, we now the owners are to pay. And I mean, that happens even if you're not insolvent or in business rescue. If you buy something on installment sales, if there's no insolvency, you just stop paying. You can't afford it anymore. They take back the car and they don't repay you what you already paid. You lose everything. So the same applies in business rescue. If the contract says the seller remains the owner until everything's been paid off, you stop paying, they get it back. Okay, let me see what is next. The consequences, okay, we've talked about the moratorium, we've talked about property. For affected persons, it has some effect. But it depends on what sort of affected person you are. Affected persons, as we now know,